Ma'am, it appears we are live.
Okay, my screen does say recording paused, so there we go. Or set it again. Okay, welcome back from lunch, everybody, or perhaps you've already had your lunch hours ago, but welcome back in any case. We're up to item number 6, update and draft legislation from the Joint Subcommittee on Mental Health and Substance Use. And Representative Larson, who is the House Chair of that, is going to present for us. At least I guess it'll be you, or do you want LSO to present it? Either way. LSO 21 LSO 225, Community Behavioral Health Priority Populations. Have a way with it, Representative Larson.
Thank you, Madam Chairman, Mr. Chairman, members of the committee. If it pleases you, I'd like to just kind of give some history on what the subcommittee has done, and then when we get into the bill, we'll have Mr. Brody walk us through that, and then we can answer questions as you deem appropriate. The legislature, Madam Chairman, as you well understand, on this committee has struggled with the appropriations and the delivery system for mental health for some time, for as long as you and I have been in the legislature, and with some limited success on trying to redefine what that model looks like. We really find the instruction for how community mental health centers operate in Title 35, Article 6. And if the members of the committee review that, they find that that is divided really into two halves. The first half of that statute is how communities and counties engage in services for providing behavioral health and those sorts of things. And then the second half of that is how the Department of Health engages into those contracts. This language was adopted in 1979 and really hasn't had a lot of changes since that time. As we have engaged in this conversation, one of the common themes that we've heard from the community mental health providers is that if you want to change it, then give us some clearer definition on what it is you expect us to do. And so that's what we've attempted to do. And the subcommittee was formed out of members of your committee and the Appropriations Committee, with you, Representative Barlow, Senator Beauchard, and Senator Schuler, joining with members of the JAC to look at that. And the governing question that the subcommittee tried to deal with was what is the role of state government in providing mental health and substance abuse services to the citizens of the state? Or in other words, what is our policy? And our intent as a subcommittee was to try and come up with a bill that would establish what the state's policy would be, and then to make the necessary changes to comply with that policy. And in an adopting policy, we used an exercise similar to what we've done when your predecessors, Chairman Harvey and Senator Scott, were working with us on the State Health Facility Task Force, and we were trying to decide what the role of state government was for those populations. And we used a similar exercise as we went through and looked at mental health. And as we look at our current mental health system, we find that it's not just this free-for-all open general access, nor is it in the purest sense a safety net where we're the provider of last resort. We're kind of in the middle there someplace. And so in a perfect world, take away the boundaries of the state and take away any requirements of fiscal requirements or challenges that we might have. We just said, as legislators deciding what policy is for the state, what is our role? Should it be more of a safety net or more of a general access? And the exercises that we went through, the members of the committee really failed to come a little more towards the safety net side than what we currently are at. And by defining that, we said that the policy of the state really should be to prioritize the populations that our general fund dollars should serve, that with our and who should those and what should those populations be. And so we went through an exercise. The members of WAMSAC went through a similar exercise, and the Department of Health went through the same exercise. And we took every individual and we decided, and we just said, who should these priority populations be? And then we ranked them, and what we really came out with was pretty much the same. That and as a precursor to that, the community mental health system is currently serving these populations now. It's just that we don't have them prioritized. They're in the mix of how we provide mental health currently. But the buckets that the prioritized priorities were that those that are involved, that are justice involved in state institutions. So that would be those who are at the state hospital, those that are coming out of the corrections or in the correction system. Title VII, it would be high needs children and adolescents who have been court ordered through DFS to have institutional diversion, preventing recidivism, and then to participate more in that recidivism and diversion through the gatekeeping process. The next priority was the non-state justice involved, and that would be your local court systems, your municipality and county courts. Then acute psychiatric, meaning those who people that are in a psychiatric crisis. They may not be involved in a judicial system, but they are in risk of or danger to themselves or to others. Those that have the inability to pay, meaning the homeless, the underserved or unserved, those without social support networks like the indigent and uninsured, unemployed or underemployed, and those that have high needs that have inability to pay. So those that have serious and persistent mental illness and without the means to pay for services. And then the need for case management to help out with people who are in need of mental health services, senior citizens, and how they can be connected to community resources. And then the last one was general access. And that focused really more on the rural areas of the state where mental health services may only be provided in our community mental health system, that there may not be other providers there. And so we thought that our recommendation as we provide this bill here is that in essence we'd be changing how we provide mental health to the citizens of the state, and that these general fund dollars now would be focused on these priority populations. And so historically, and not really well defined in statute, what we have is kind of a reimbursement block grant to the community mental health providers, and kind of depending on who comes in the door, they have the ability to take insurance and bill Medicaid, private payer, but it's just a mix of all populations, and then they're responsible to come up with 10% of their costs. This would be a pretty significant shift, Madam Chairman and members of the committee, where we would say that you have a business model as a community mental health provider, and anybody can come in your door and receive services. Those that have the ability to pay, meaning private funds, insurance, Medicaid, those would be the means whereby you would be reimbursed for those services. But then the state, those that enter into a contract with the state as a behavioral health center would have access to general fund dollars to provide services to these priority populations. meaning the justice involved, the acute psychiatric, those that are families that are in crisis, and people with high needs and inability to pay, those that we lined out. And then we identified those groups and put them into tiers. And the reason we put them into tiers is tier 1, tier 2, is that you may have a behavioral health center in one part of the state that doesn't see the same populations as a similar one in another part of the state. And they would be able in their contract to move the populations within the tier to help compensate for their revenue stream. The one other thing that we tried to address that you'll understand as we go through here is going back to this, what do we do in these rural counties where there are no other services? And if we are only providing funding for this priority population, their business, their clientele through the other business model may not be sufficient for them to meet all the expenses that they have. And so as part of this, we recognize that and offer to provide a grant to those in rural communities where services aren't available to help with the operations and maintenance costs of the facility, not so much reimbursement for general access populations, but just a resource to help provide these mental health services in some of these communities. And I think that you'll see that, or if you may have seen it in the language. So then, Madam Chairman, with all of that in mind, as we move forward, then that gives us the ability as a state, as our revenues fluctuate up and down, how then we can provide these services and focus on priority populations and give a little more definition to these behavioral health centers, as we'll call them. And the reason we call them behavioral health centers is that's if you look at the term mental illness does not include substance abuse. If you want to include substance abuse, then it's behavioral health, as I found out. And so that's hence that little tweak in the name change, because this will focus on both mental health and substance abuse. So, Madam Chairman, I think that I hope that you said in those meetings, I hope that gives you the committee kind of a brief outline. It was a pretty broad undertaking, and it took Mr. Brody and Ms. Martineau a significant amount of effort working with the Department of Health to whittle this down. I think we're on version 12, but it's taken, they've been really diligent in working through, and we've tried to answer questions that the community mental health providers have. And so with that, this might be the time where we turn it to Mr. Brody and just have him start walking us through there, unless you would like to do otherwise, Madam Chairman.
No, roughly that. But first, if I can just confirm with Mr. Brody. So the version that I have printed off, but perhaps I was too soon on it, I have version 10. Is that the most current? What is the most current version, Mr. Brody?
Madam Chairman, it's version 12.
Oh.
Madam Chairman, it is version 12, and version 12 is up on the legislative website right now.
All right, give me 1 second so I can print off a copy of the most current version, committee. I'm gonna take just 1 second there.
Madam Chairman, while you're doing that, and Mr. Chairman, as we look in this in chapter 35, chapter 6, this committee may want to look back on this as when all of the dust settles. Again, this came back in 1979 when counties contracted for services for the developmentally disabled and crisis shelters and things of that. It's probably time for some change in this statute. It's got some gray hairs in it that need to be trimmed or replaced. Another day, but we shouldn't lose track of it.
Okay, sorry about that. I had to, I'll, in a minute, I'll run over to the printer and get that. Committee, just before Mr. Brody starts, I just want to insert one thought here. With all due respect to appropriations. And that is that you all know what budget situation we are in at the state. There may be components of this bill that we say, well, we just don't like the arrangement, or we don't like this, or this needs more. Those are all good input that we can have, and it's a bill that we can vote on to run. However, I would just say that if we fail to run a bill that has a prioritization, very likely JAC will end up doing the prioritization for us. And having, as I say, with all due respect, but having served down there for 2 years, if we let them do it, we probably won't like the output. So I would say, just keep that in mind as we go through the bill, because it's not really going to be within our ability to say, and the outcome of the bill is to add $10 million to every category plus 3 new categories. So I don't, with that said, Mr. Brody, I'm going to run off and get my bill. You go ahead and start, because I certainly, unless you really messed up the first page, I'm all right for that.
Madam Chairman, I think the first page is good. John Brody, Legislative Service Office. Before I kind of get into the details of the bill, I wanted to kind of paint maybe a broad picture of the mechanics of the bill. So Section 1 is going to be the statutory changes that are put in place in Title 25 in regard to the community mental health centers and the services that are funded by the state and the delivery of those services. This first section of the bill has a delayed effective date of 1 year. And the reason for that is that Section 3 of the bill requires that the Department of Health work with all the vested stakeholders that work in the area of behavioral health and have pretty intense conversations in regard to a number of the policies that are put forward through Section 1. Those discussions will occur, and then under the bill, the Department of Health is required to report the information and findings back to the Labor Committee, I believe by the end of July. Basically this would allow for the Joint Labor Committee to perhaps change what may happen during this session with regard to Section 1, to add to it, to maybe go a different direction, but it would allow for the policy to be put in place, but then allow for the details to be fleshed out and make sure everybody's on the same page. So I guess I just wanted to kind of put that out there. So going into page 2 and 3 are going to deal with Title 25. One of the directives that this bill provides to the Department of Health when it's contracting with what we're calling now behavioral health centers is that behavioral health centers will be prioritized as the gatekeepers when under Title 25 and the delivery of those services. So when you look at Title 25, mostly the changes have to do with the delivery of the gatekeeping services. Specifically, if on page 3, we talk about how the department in consultation with each Board of County Commissioners can select a gatekeeper or a single point of responsibility. So what we did is we added a sentence that in having those sort of collaborations, that they would prioritize gatekeepers to the extent that that was possible. Now, moving to the next page, subsection J, starting on line 1, what that does is at the end of that provision, it allows the Department of Health to assume many of the expenses associated with providing those gatekeeper services. Because the policy in this bill is to prioritize these behavioral health centers, we have now required that if the Department of Health is going to provide any sort of payment when it comes to gatekeeping services, then it is a behavioral health center that has to have been designated as the gatekeeper.
Madam Chairman. Madam Chairman.
You need to unmute yourself.
Sorry. I was trying to be so good when Representative Larson was talking and not rustle my papers. Chairman Scott, were you wanting to be called upon?
Yeah, Madam Chairman, a question on this gatekeeper section. Have there been some problems with the current setup that has caused us to focus that on the behavioral health centers, or what's the reason for the change? I think I understand the change. Why is the question?
Mr. Brody or Representative Larson?
Madam Chairman, the discussion that we had was trying to bring some conformity statewide on what gatekeeping policy is. It's really provided and administered and frankly defined differently around the state, and we're trying to bring some continuity to where it's a standard that can be whether you're in Niobrara County or Uintah County, it would the term and the services and the expectations would be the same.
Representative Clem.
Yeah, thank you, Madam Chairman. Just a question, why are we eliminating the provision on co-occurring disorders in this? Thank you.
Representative Clem, what page are you on? Or where are you at?
Madam Chairman, that is on top of page 2, no, excuse me, top of page 3. This is in the definition of mental illness and mentally ill. And then on page 3, lines 1, 2, and 3, we strike that except when one or more of these conditions co-occurs as a secondary diagnosis with mental illness. So those are co-occurring disorders. I just don't know the reason why we're eliminating that. Are we saying that we're not going, if there's a co-occurring disorder where someone is mentally ill and they self-medicate with alcohol or perhaps drugs, we're not going to address the drug problem? I mean, those co-occurring disorders, you treat it kind of one and the same. I'm just curious why the elimination.
Representative Larson.
Madam Chairman, it's purely definition. Mental illness is not substance abuse. And the intent there is to serve mental illness and substance abuse, and we wouldn't argue and don't argue at all that they co-occur and need to be treated. But we're just really trying to look at a pure definition of what mental illness is, and mental illness is not, if it's truly mental illness, it's not a co-occurring with substance abuse, and it's not this exception thing, and that's really what it is. If you leave that language, if for some reason you left that language in there, it would still mean that you would have to be mentally ill and have a substance abuse or similar co-occurring issue taking place to do that. But when we looked at the definition, we questioned why is the reference or why is substance abuse there in the purest form. And so it really is just a definition of mental illness and not of anything else.
Thank you, Madam Chairman. Just to follow up on that,
Representative Clem.
does that, I don't know the previous history with the statute, and so I just know that co-occurring disorders are listed in the DSM-5. I just wonder, are we as a state moving away from that? I guess I'm not quite sure that I understand the ramification of this, because I know, in the definition of mental illness there, we're saying in the page 2, line 22, it does not include addiction to drugs or alcohol, drug or alcohol intoxication, or developmental disabilities. And then we remove except when one or more of these conditions co-occurs as a secondary diagnosis with mental illness. So I guess I don't know. And it's not that we need to get bogged down here. I just really am uncertain of that and how that's going to play into things.
Madam,
I do think that if we kind of back up and look at that paragraph, because it is a sort of a paragraph which really could stand some more periods in it, but right before deleting it, basically it's saying mental illness means, and I'm going to skip a bunch of stuff, but mental illness means a mental disorder that includes addiction to drugs and alcohol. I mean, you know, that's not what we mean. Mental illness, you could be mentally ill and not have any of those things. So the thing is, we're not saying that we're not treating people with co-occurring disorders. We're just saying that mental illness doesn't include addiction. In other words, if you have an addiction, that doesn't make you mentally ill.
Right.
You know.
Madam Chairman, and I would agree. And that that paragraph already said that, but what's taken out is the co-occurring portion, in that drugs or alcohol addiction in and of himself isn't mental illness. The previous paragraph, the existing statute, says that too. But it does say that a co-occurring disorder is a mental illness when you have a primary mental illness and underlying that you have an addiction on top of that. And that's what we're eliminating. And I guess I'm just, how it plays into this, if we're prioritizing things, are we saying that we are not going to prioritize those who have co-occurring disorders? I'm just trying to follow this rabbit trail and see where it goes. And that's where I get concerned.
Yeah, I don't think we're saying that at all, but let's work our way into the meat beyond just the definitions. Was there another question?
Yes, Madam Chairman.
Chairman Scott.
Following up on that, if we take this out, are we going to have the unintended consequence of having either some bureaucrat or some attorney read and say, okay, with this out of there, if you've got a substance abuse problem as well as a mental illness, you aren't mentally ill by the definition. Could it be the way it's used back in the bill? Could it be misread that way and get us in trouble?
Well, let's keep these questions in mind and work. It's a lengthy bill, 24 pages. So let's make notes to yourselves and let's get to the end before we circle back. Go ahead, Mr. Brody.
Thank you, Madam Chairman. So beginning on page 4, line 15, we get into Title 35 and the kind of meat of what this bill is. A lot of the changes that we'll be going through are really just a bunch of conforming changes and updating some of the verbiage to kind of current terminology. For example, if you look at page 5, line 9, in a general sense, we don't refer to people with substance abuse. We refer to substance use disorders. So there's changes throughout that chapter, which make that change and just kind of update the language. Now, beginning on page 6, this is the definition section of that area of law. And this is where we get into defining the priority populations, defining what a priority population is, defining mental illness and things of that nature. So I don't know how, Madam Chairman, how detailed you'd like me to go into each definition, or if you'd like me to kind of just hit the high points, but I can do as you please.
Actually, let me just momentarily back up there. So to that point about the definitions, the question back on the pages 2 and 3, you'll note that's in Title 25, which is that's in the criminal section, right? Under what we refer to as Title 25. So those definitions are not actually in the Title 35. I mean, the question that we just addressed, noting, just pointing out that we have two separate sets of definitions here. The change in Title 25, and now we're picking up on page 5 with definitions in Title 35, just so that we have noticed that. Mr. Brody, I think just because this is such a thick bill, and even though I don't want to drag on, I think it would probably be good to at least just touch base on all of the on it, so that people can really mark it up, because it is a pretty thick bill.
Okay.
Madam Chairman, Eric.
Representative Barlow.
Madam Chairman, I just want to clarify, when you refer to Title 25, I think you said criminal, and it's actually involuntary hospitalization
Oh, sorry.
and that stuff.
I
So
misspoke.
just for
Right, but I-
clarification that
Yeah, that's good.
we're describing it. Thank you.
And what section of the, I don't have my statute book out. What, you worked on that so significantly. Title 25 is, I mean, what are the surrounding titles in there? Or is that just a standalone thing?
Madam Chairman, Title 25, Chapter 10 is all of the involuntary hospitalization, directed outpatient, all of that chapter is regarding that issue.
Okay. So anyway, good.
The
good,
rest of
good.
Title 25 chapter I can't tell you, but that is what it is all regarding. Thank you.
Anyway, that's so good. So just so that we notice that those are different there. Okay, Mr. Brody, I believe you want to pick up actually page 5 is the substance use, but okay, just picking up on 6, especially. Well, I see the top of 6 has got that too. Go on.
Yeah, so I guess I'll note that we made the definition of mental illness. We tried to be consistent with the definition that's offered in Title 25. You'll see that it includes the language, but does not include addiction to drugs or alcohol, et cetera, but doesn't include the language that was stricken in the definition from Title 25. Moving to line 16, adults with acute mental illness. So this is a priority population. It's a tier 1 population. We'll get to the tiers later in the bill. But based on kind of the working group and the number of stakeholders that had input in this process, we've defined what type of individuals are going to be included as part of adults with acute mental illness. Now, it's going to be folks who are subject to an emergency detention under 2510-109, folks that have been directed for an involuntary hospitalization under 2510-110, or folks that have been directed for outpatient commitment under 2510-110.1. The latter part of that provision, and you'll see this kind of language repeated throughout a number of the priority populations, states that or were released from those sorts of circumstances within the last 6 months. There's no magic number for that period of 6 months. It just seemed that it would be, and again, I'm speaking just as the part of the committee deliberations, but it seemed good policy to have a bit of a grace period when it came to a lot of these priority populations. So 6 months was the number that was provided in the bill, but certainly there's no magic to it. Moving to page 7, this is the definition of behavioral health center. Now, this is kind of what this whole
Madam Chairman.
Senator Scott.
Madam Chairman.
Senator Scott. You're muted, sir, Mr. Chairman Scott.
Madam Chairman, I've got a real question with regard to the definition on XIV. The way I read it is you have to get in some kind of trouble, either with the law or involuntary commitment or something like that. And if somebody comes down with a mental illness, say schizophrenia, where you do sometimes have a fairly sudden onset, and they do something voluntary, they're out of the priority population. And my question is, why do we write it that way? Are we forcing people to get in trouble first when some of them either directly or because they have a family that pressures them, try to get it taken care of before they get in trouble? Are we causing a difficulty here?
And Chairman Scott, that's a good question. And I think if you've got Post-its or something there, put a Post-it there. They may or may not be picked up again later. I've had some discussion with Representative Larson about this issue. Let's keep going so as to not get too bogged down. But mark the pages where we want to have some further discussion. But just so that we can have the whole thing in our head before we start working on a paragraph. But certainly that's a paragraph that I have marked up in the past. Okay, Mr. Brody, go ahead.
Thank you, Madam Chairman. So beginning on page 7, we have a definition of what is now a behavioral health center. Under the current system, we have community mental health centers that are providing the services that are funded through the state. However, we've never even specified what these centers are in statute, and the approach is that providing a statutory definition will provide a bit more clarity. So this language is generated from some of the language that was provided in Title 25 in the definition of a mental health center. It's also language that was brought from the contract provisions that the community mental health centers sign with the Department of Health. Basically, it means a nationally accredited organization that's licensed through the state and provides a comprehensive range of services for the treatment and management of mental illness and substance use disorders for priority populations. So that is, in a large part, that is the policy of this bill. Moving to line 9, we have the next, or one of the
Madam
other
Chairman.
one.
Chairman Scott.
Madam Chairman, on this definition, my question is, are we excluding any of the current mental health centers or substance abuse centers? And my understanding is that in many communities, they're one and the same, but not always. And it looks to me like this requires them to do both things in order to qualify. Are we going to have some unintended consequences here? What's the consequence of this change?
Representative Larson.
Madam Chairman and Chairman Scott, again, if you'll just bear with us a little bit, I think you'll find that, and you're correct, in some parts of the state, we have some those services bifurcated, and we make allocation or we take care of that later in the bill. This is a definition of a behavioral health center. Again, just a definition. And if they can't provide all the services that the Department of Health, then we give some flexibility to bring in another service provider to help do that.
Go ahead, Mr. Brody.
Thank you, Madam Chair. As I was saying, beginning on line 9, we have another priority population, a tier 1 population called the families at high risk. This has multiple types or categories of folks that fall into this. The first, under paragraph A, is going to be children who have been discharged from an acute psychiatric facility or a psychiatric residential facility. And then again, it has that language with the 6-month grace period. Also included within this definition are going to be a child or the parent, legal guardian, or other immediate family member of a child, as defined by rule of the Department of Family Services. The reason that provision is in there, in the discussions with the Department of Family Services, they have specific requirements that they have to meet in order to receive federal funding and operate a number of programs. So we tried to recognize that fact and provided them with rulemaking authority so that they can define any other type of family figure that would also fall into the equation under these circumstances. But with that said, it would be those individuals. Madam Chair, I believe Representative Wilson, or excuse me, Larson has a comment.
Representative Larson.
Madam Chairman, because we'll continue to see this throughout the bill, that reference to 6 months, you know, that is a little bit of an arbitrary number, and you know, that's probably the main thing we get questioned on. We haven't tied our horse up to that very tight at all. But more importantly, that isn't the length of time they can get services. They just had to, that is their eligibility time within that 6 months. We realize that those services may take place for an extended period of time, and so it's not like they can only get services for 6 months. It's just, we felt like that there has to be a period of time in there that they qualify for those services, and that's what that time frame does. Just bear that in mind. That's what our intent is. Whether that's what the committee does with it is just wanted to help people understand.
Good. Go ahead, Mr. Brody.
Thank you, Madam Chair. So as I was saying, under the paragraph B, line 17, this would capture those individuals as defined by Department of Family Services who have been referred to a behavioral health center by DFS to receive treatment for a mental illness or a substance use disorder. And that treatment would have been necessary to prevent the removal of a child from the child's home or to reunify the child with the child's family. Moving to the next definition, we define general access clients. General access clients under the structure of this bill are not a priority population. The reason this term is defined is that, as Chairman Larson had mentioned, we have created what's been called an essential subsidy payment for behavioral health centers who will serve general access clients and need some assistance in order to keep the doors open, keep the lights on. So that's just the kind of catch-all definition for general access.
Chairman Scott.
Madam Chairman, my question is on that. In our community, which of course one of the larger ones in the state, I've known a number of people who have had mental illnesses that were fairly debilitating, that had gone to our community mental health center and received very valuable treatment. And as I read this, in the larger communities, that can no longer happen. Is there evidence that there's enough private providers out there to get the job done, or are they still going to treat them? I'm unclear of the implications of that one. I can understand why it needs to be done in the rural areas, but it's been very valuable to a number of my constituents.
So and I'll call on Representative Larson in a minute, but my take on this, Chairman Scott and committee, would be, we're not saying that these centers can't provide these services to these other people. What we're saying is that with our state general fund dollars, this is who you need to prioritize. Certainly other patients, if you can bill for their insurance or you do local fundraising or whatever, that's available. And I'll call on Representative Larson here, but just again, remember, if we don't prioritize limited funds, very likely someone else will prioritize it for us. Chairman or Representative Larson.
Madam Chairman, you are correct. And Senator Scott, just to reiterate, these providers, these behavioral health centers have a business model that provides services to anybody. The doors are open, anybody can come there. But the reimbursement of state funds will only be through them for priority populations.
Representative Clem.
Thank you, Madam Chairman. So just looking at these definitions again, on page 7, I'm looking at paragraph B in particular, and I'm just trying to play this out practically. So the S House, for instance, in my neck of the woods would be considered a behavioral health center. But as far as prioritizing, I don't know if it needs to be further defined, because I'm assuming here these top tier individuals would be those with very significant issues. But we do have, for instance, kids and families that are referred from the Department of Family Services to the Yes House, but not for like residential treatment. Sometimes they're referred for just outpatient services. And so this behavioral health center, it's referred to a behavioral health center, but the services vary greatly is what I'm trying to say. And so what a tier could essentially under this unintendedly mean that someone who is referred by DFS to outpatient treatment or to day treatment at where they could have been referred to outpatient treatment with another provider in town, could it be that they're now a tier 1 recipient and prioritized in that way? I'm just curious on that. That's kind of my initial take on that, and just want to know your thoughts.
I'm not sure I understood the question, but we'll let Representative Larson try.
Madam Chairman and Representative Clem, I'll give you the intent of why we've got those two paragraphs. And your question, I think, is a good one to bring up. So if there's a judicial decree, the child is pulled from the home, then the child's automatically on Medicaid. And so the Behavioral Health Center, the PRTF, RTC, they can bill Medicaid for those services. And this is in A, but the family may not be covered by Medicaid. And so this covers them as well for services to make sure that the family can be reunited or do whatever. Kind of fits into this family first thing. But then in talking to the department, you may also have families that come in and are not under the jurisdiction of the Department of Health. And so Medicaid may not, it may, but it certainly may not come into play as a funding source. And so then we want to make sure that child or the parent or the legal guardian has access to counseling or services that would allow for the family to be to stay together. Now, and so we do put that in a tier 1 for reimbursement. Now, are there other providers that could provide that counseling service to the child or to the family? I'm taking from your comments that may indeed be the case. How do they get reimbursed, or how do they get paid now if they're referred by DFS? Is that a payment directly to them from DFS, or is it a responsibility of the family that's receiving services? And I can't answer that. So I think it's a good question, but the intent of this language was for those families that do not have resources, that they could come to a behavioral health center, receive the services that they needed, that before a judicial decree took place that would prevent a child from being removed from the family.
Chairman Scott. Chairman Scott, you've disappeared entirely. Well, we'll come back to Chairman Scott. Mr. Brody, I've lost track. Are we on page 8 yet? I think we are. Or go ahead, Mr. Oh, nope, there's the chairman. Chairman Scott, we lost you. Were you trying to ask a question? You're on mute. You're still on mute, Chairman Scott.
Okay. Madam Chairman?
Yes, now you've turned your camera off again, but I guess as long as you can talk, that's okay.
I may be having trouble with my bandwidth, being unable to handle both of them at once. Page 7, line 20, is somebody has to be referred by a behavioral mental health center. Are we getting ourselves in trouble here in the counties where the mental health center doesn't qualify because it doesn't offer both services? Is this a place where that new definition is causing us trouble?
Representative Larson?
Madam Chairman and Chairman Scott, I don't think it is. But as we go through the bill, if we need to tighten that up, but I don't think the definition, if I'm understanding you correctly, if you have a family that maybe comes in and the Department of Family Services determines that they may be in risk because of whatever the situation may be, that a child could possibly be removed from their house and they require counseling or substance abuse counseling, and there's a behavioral health center that doesn't provide that in their community, but yet this says that they're referring to a behavioral health center. I think later on, we see that the contract allows, if the behavioral health center cannot provide all the services, that the contract would also include the other entity providing or filling the gap on those services that they can't provide. I don't think that definition strangles the cat there.
Okay, mark it up though, folks. Just keep marking and be patient to the end. Mr. Brody, on page 8 again, I believe.
Yeah, and Madam Chairman, just to expand upon that, maybe just a little bit. There is a provision later in the bill that gives the Department of Health the authority to contract with non-behavioral health center providers if, under the circumstance that the behavioral health center, for whatever reason in the community, simply cannot provide the services that are necessary. So the discretion is given to the Department of Health when those circumstances arise to give them a bit of flexibility. And that's on page 14 of the bill, and I'll get to that certainly in due course.
Okay. People need to get some more Post-its maybe. Go ahead, Mr. Brody.
Yeah, so I guess moving along, page 8, line 8. This is the next sort of priority population that we've put in through policy. This is going to be a tier 2 priority. Indigent general access clients. These are going to mean people who do not have private or public health insurance that provides coverage for mental illness or substance use disorder treatment, and whose total household income is not more than 100% of the federal poverty level. Now, as LSO is working through this bill language and as part of the working groups that really created this bill, there was discussion on this FPL level of 100%. Why is it not higher? If you look at Wyoming statute, it's about the lowest that we would have. And the reason, and this language was actually brought forward by the Department of Health, and the reason that they chose 100% has to do with Obamacare and the fact that at 100%, you're basically in I'll call it maybe a dead zone where you can't get on the marketplace to get affordable health insurance. So you're kind of out of options. So the intent of this provision was to capture those folks that can't qualify for all the various insurance options that are out there and really need services and have nowhere else to go. We then move to the next definition on line 15. This is indigent clients with high needs. This is going to be those folks that meet the definition of indigent general access and that who also have a mental illness or substance use disorder that substantially impairs their ability to function in society. Now, the intent I think the intent of this provision was to capture those folks that have more serious substance use disorders, more serious mental illness occurring that really it's causing a real problem in the way they conduct their lives. This language was borrowed from the definition of developmental disability in this chapter, and I think the idea would be that if this doesn't provide enough clarity, that the Department of Health would be able to use its rulemaking authority to put more sideboards on really what it's the population that needs to be served that's being substantially impaired. So that's sort of the background on that provision.
And let me just insert committee. Remember, this is still the definitions. This is not the prioritization. This is just still under definitions, okay? The prioritization comes in a little while. Go ahead, Mr. Brody.
Thank you, Madam Chair. So bottom of page 8, moving on to page 9, this is going to be non-state justice involved. What we're trying to do here is capture all the folks that don't fall under your quote unquote state institutions. So this is going to be, and again, you see the 6-month language, but this is going to be people who have been placed on probation and made subject to an intensive supervision program under Title VII, that requires treatment for a mental illness or substance use disorder. Line 7, it's going to be people that are convicted or pled nolo contendere to a criminal offense in order to enroll in an intensive treatment program for a mental illness or substance use disorder. It's going to be folks starting on line 13 who are on probation, parole, or have been conditionally released and are ordered to receive mental illness or substance use disorder treatment as a part of the sanctions under the new chapter 13, article 18. This is that justice reinvestment area of statute that was put into place just, I believe, 2 years ago. And then it would also relate to qualified offenders under 713, 1301 through 1304, and those folks that have been required to receive treatment for a substance use disorder. Moving on to page 10, this is kind of where it all sort of comes together, so to speak. This is what the definition of a priority population is. So beginning on line 5, we have the state level justice involved, which I'll get to. We have the non-state level justice involved, which I just discussed. We have families at high risk. We have adults with acute mental illness. We have indigent clients with high needs, and we have indigent general access clients. So as I mentioned, the paragraph or subparagraph A, paragraph A, state level justice involved. This is going to mean folks that were within the previous 6 months have been released or paroled from an institution as defined by 713-401. That's going to be Department of Corrections. Released or discharged from a facility as defined under 711-301. That's going to be mentally ill folks that are not guilty by mental insanity. And then and folks who require continuing treatment for mental illness or substance use disorders. Then moving on to page 11, this is just a conforming amendment to make sure that all the definitions line up. Beginning on line 5, we have a number of conforming amendments that are going to run throughout the bill that really just recognize the fact that in addition to the other sort of human service programming that's under this existing title, we now introduce this concept of behavioral health centers and their attendant priority populations. So page 11 deals with that. Page 12 largely does too. We're just updating some of the language there on lines 8 and 9. Moving on to page 13. Again, behavioral health centers being introduced and then updating the language regarding substance abuse. And so I guess on page 14, this is these are material provisions of the bill. And page 14 are some of the provisions that are directives to the Department of Health on what they must do, what they shall do under this new system. So page 14, line 5, we have required the Department of Health to establish payment policies for state-funded services provided to priority populations. And these payment policies have to take into account a client's ability to pay and utilize general funds authorized for expenditure as the payment of last resort. Really, functionally what this provision is supposed to do is put the directive to Department of Health that they're supposed to look at all other options that may be available for the payment of services that are provided through these behavioral health centers. Use those first, and if a certain individual within a priority population still needs assistance, then they are to use this general funds that are appropriated. Line 13, they are to prioritize behavioral health centers as the providers of state-funded services. This is the provision I mentioned earlier that provides flexibility to the Department of Health to contract with other providers if a behavioral health center simply just cannot fulfill that role. So if a behavioral health center cannot provide sufficient services, the Department of Health shall select the most appropriate service provider in order to achieve an effective and efficient delivery of mental illness and substance use disorder services and human services programming. So if there's a circumstance where perhaps the behavioral health center doesn't meet, or a current quote unquote behavioral health center doesn't meet the definition of what this bill provides as a behavioral health center, this provision would allow the Department of Health to contract to provide the services that are necessary within that community as a result. Moving to line 22, this directs the Department of Health to prioritize the delivery of state-funded services to priority populations and allocate services between priority populations in the following order of priority. Now, what this is, I spoke earlier about the priority tiers, and we have tier 1, tier 2, and tier 3. Now, if you go back on page 10 is where we have the definition of priority populations. A through D is now a tier 1 priority population. Representative Larson had spoken about giving the Department of Health, or the contracting with the Department of Health, the flexibility to essentially identify priority populations that may be more, there may be a stronger population of families at high risk, for example, in one county versus non-state level justice involved in another county. And this would give the Department of Health the flexibility to perhaps contract dollars in relation to those variances between communities. But that flexibility would be tied to the fact that it has to be within a tier. So state level justice involved, non-state level justice involved, families at high risk, and adults with acute mental illness is now a tier 1 population. Excuse me, line 9 is a tier 2 population. This is going to be the paragraph E from line 10. This is going to be those indigent clients with high needs. And then the final tier priority is going to be indigent general access clients, as we've discussed. Moving on to line 15, this is the provision that I kind of mentioned earlier about these essential subsidy payments. And I'll just go through the provision because it's pretty important. So subject to the priority population tier requirements under paragraph 9 of this subsection, and in addition to other contractual payments to behavioral health centers and other service providers under this act, the department shall provide essential subsidy payments to eligible behavioral health centers or to other eligible service providers under paragraph 6 of this subsection to help defer continuing operating costs. A behavioral health center or other service provider under this paragraph, under paragraph 6 of this subsection, shall be eligible to receive the essential subsidy payments only upon demonstrating a need for operational cost assistance as determined by rule of the department. The amount of any subsidy payment, essential subsidy payment, shall be subject to available funding and based on the total population of the geographic area served by the behavioral health center or other provider and the number of other behavioral health care providers within a 35-mile radius. Now, essentially what this is trying to accomplish is there was a concern by the committee that we needed to maintain the infrastructure in the rural areas of the state. And there may be behavioral health centers out there that simply don't serve enough of the priority populations to perhaps maintain the business. And this provision is hoping to recognize that fact and provide an essential subsidy payment to those businesses to keep the doors open so they can continue to provide services in their community. In that same vein, there also may be communities that don't have a behavioral mental health center, but are those providers that the Department of Health is contracted with to provide those essential services that a behavioral health center would have otherwise provided, as I've discussed, that was on page 14. So what this section does is it recognizes that those types of providers are out there as well, that they are essential and that they can qualify for this essential subsidy payment just in the same manner as a behavioral health center. And then on line 11, this is just sort of a more of a housekeeping provision, but this is the sort of flip side of the coin of the changes we made in Title 25, and it just directs the Department of Health to prioritize behavioral health centers for gatekeeping services. Bottom of page 16, that's just a conforming amendment. Page 17, line 13.
Madam Chairman.
Oh, Madam Chairman.
Madam Chairman.
Yes, go.
Muted, Sue.
Well, I don't know how I got muted. Go ahead, Chairman Scott.
Madam Chairman, I'm having trouble with the bandwidth on my side. So this is the second time with this. The provision on page 16, line 11, where they've got to prioritize behavioral health centers. This seems to me to be not covered by the exception we put in for the contracting on page 14. And there's several of these. I think that we're really starting to say that if you're not serving both populations, you're second class, and forcing a change in our delivery system. Is this something we really want to do?
Representative Larson.
Thank you, Madam Chairman. I don't know that I have a response to that. I guess I'm not seeing it the same way that the good chairman is, and perhaps if he could elaborate a little bit on how we're making that appear to be discriminatory, that would help me maybe to better understand.
Chairman Scott.
Madam Chairman, as I read it, in order to be prioritized for delivery of gatekeeping services, you have to be a behavioral health center. If you're just a mental health center, you're not prioritized. Is that the intent of the committee, trying to force all the mental health centers to also be substance abuse centers? I mean, that's a possibility that we could do that, because they are linked sometimes. But the way it's written here, I think it does say if you're just a mental health center, we can contract with you, but we can't prioritize you for gatekeeping services. We can't give priority to the clients that are served through you, as in the priority population definition. I really wonder, have we thought this one out as to why we're doing it the way we're doing it?
Representative Larson.
Madam Chairman, and then, so you are correct in the aspect, Senator Scott, Madam Chairman, Senator Scott, in that this is really focusing on the Department of Health's contract with behavioral health centers and the requirements or expectations we have for them, defining what populations we will serve with state general fund dollars. Again, I think it's really important on page 14 to understand that if a behavioral health center can't provide sufficient services, the department then has the flexibility to select the most appropriate service provider to fill in the gap there. So then, as we come over to your point on 16, that that we're prioritizing, and indeed we are prioritizing behavioral health centers to be the gatekeepers as well. If they can't provide that in the community, then they could contract for gatekeeping services to a mental health provider. But you to the point that we are focusing on community, on the behavioral health centers, that is correct.
So I guess following up there, and I'm sure we can hear from people testifying later, but are there gatekeepers in counties currently that are not the current community mental health centers? I mean, are there some communities who have just contracted with a local private practice psychologist to be the gatekeeper, for example?
Madam Chairman,
know?
My understanding to that, and Representative Barlow probably has a better handle on that, but my understanding back from the Department of Health and from some of the mental health providers is that from the judicial system is that kind of is one of the problems, is there is not a defined there isn't anything that defines what just really who should be providing those services and what we expect out of them. There's not conformity from county to county on this is what's expected in gatekeeping services. It's kind of left up to the county and those providing the services to determine what that contract's going to read. But then as we've heard the counties pitch in and say, gee, state, we would like you to cover more of these costs. We would really like to have our community mental health providers helping us out here a little bit in diverting these people from the state hospital and where are they when they come out of the state hospital? Well, then that fits more back into this realm of the behavioral health centers or the community mental health centers that we're focusing on. And so then trying to pin all of that kind of within the SAFE guidelines made sense to us to include that in the bill to where it's the same throughout the state as best as we can.
Representative Barlow, did you have some input there?
So, Madam Chairman, first of all, the gatekeeper concept is Title 25, the involuntary hospitalization, that particular issue. That's where that comes from, as you'll recall from several years ago. And currently, the way the statute reads in Title 25, 112G is that the department, in consultation with county commissioners, may establish a single point of responsibility. If you go further down in the same paragraph, then it says anybody can actually contract to coordinate and et cetera services. But we're trying to do is tighten that up so that if the Department of Health is going to be spending general fund dollars, particularly on the Title 25, those folks, that we have some level of conformity or continuity across the state in how services are being provided and by whom. So look, it would be ideal if we cleaned up Title 25 and this at the same time and really rebuilt the whole system, as Representative Larson spoke about earlier. Right now, we're just trying to fix one part of it and make it comport with existing statute. Thank you, Madam Chair.
Okay, so put Post-its here if you like. Let's keep forging forward. I believe we are on the bottom of page 16. Is that where we are, Mr. Birdie?
Madam Chairman, I believe we're on page 17 now, but I can.
Okay, carry on.
So page 17, beginning on line 8, this is an existing statute that kind of puts some requirements on the department in their budget requests. The idea on line 13 with that provision was to include as part of their request for the department to basically explain to the legislature what funding it would need in order to serve the policy of providing services to priority populations. So this kind of seemed just like a good place in the bill to maybe have some data that would be communicated to the legislature so that they could know, how the funds are working or what funds would be needed and where. The rest of page 17 is really just housekeeping. Page 18, housekeeping. Page 19, housekeeping. Page 20, line 8. This is a little bit of repeal of obsolete language. There were discussions with the Department of Health, with the working group, on what provisions in this article were really necessary. And in large part, it seems, as Representative Larson indicated, there's a lot of cleanup effort that could be had. However, we didn't want to divert the mission of what this bill is. So these provisions that are being repealed, there really was no debate with any of the stakeholders or committee members as to whether or not these present statutes still serve a purpose. So this is really just housekeeping to get rid of provisions that really have no use today.
Mr. Birdie, could just give us a rough idea of what they are? And I obviously, and I'm sure you guys are better at this than I, but I guess repealing obsolete provisions obviously covers a lot of things, but just you don't need to read them all, but so that I don't have to look them all up, just give me a general gist of what they are.
Okay, so for example, the first one, 351620B4. This is one of the directives that was given to the Department of Health under the old kind of structure of the statute. And it required the Department of Health to review and comment on any application for funds submitted by an entity to the federal government for human services programming. In discussions with the working group and the Department of Health, this sort of process just doesn't really happen anymore. For example, developmental disabilities aren't handled in this title anymore to the large extent. They're handled under the waiver. So I guess that would be one example. Paragraph 5, review and evaluate all programs authorized or funded under this act other than programs providing for shelter care services or victims of domestic abuse or sexual assault. Again, this is all part of sort of the contracting provisions. The Department of Health does this anyway. The feeling, I believe, from the working group is that it really wasn't necessary to spell this out in statute. The same goes for paragraph 8. Paragraph 8 said that as a condition of eligibility, you basically cannot discriminate on somebody's race, creed, color, national origin, or inability to pay. And because we're moving away from a general access system, and then the other components are protected under federal law, the United States Supreme Court cases, among other things, that was really kind of a superfluous provision that wasn't really necessary in Wyoming statute anymore.
Okay, that's good.
So I guess moving on into section 3, this is kind of what I discussed.
Madam Chairman,
Chairman Scott.
Madam Chairman, on the repealer section. The question on 351622B, that's the local matching funds provision. That one, I don't recall the occasion for the Senate debate on it, whether it was to put this provision in to start with, or whether somebody tried to take it out and the debate was over that. But I do recall an extensive Senate debate here that there was major value in having a local match required so they would continue to be responsive to local needs. Why are we taking that out?
Mr. Representative Larson.
Madam Chairman, thank you. And Senator Scott, again, we've kind of gone away from the model of reimbursing them to general access for populations. This is, as you well know, this is similar to what we have with the developmental preschools, except theirs is they develop 3%. We give them X amount of funding to provide that services, as we did the community mental health centers, and they can collect from insurance and everything else. But because of this general fund amount that we are giving them, basically for this broad array of state citizens, we're saying you've got to in that community, you have to come up with 10% on your own. We've changed that now. We're saying we're providing state dollars for these priority populations. The rest of the population that you serve through general access is like any other mental health provider, where the door's open, you provide the services, you charge, and you get that. And so we felt that it was appropriate to move the requirement of having to come up with 10% in largely because is it 10% of what? Is it 10% of what they're going to be reimbursed because we've changed the model? Is it 10% of last year's overall expenses? What is the 10% now that we're having them come up with? And then as well, for the general access clients, there are other mental health providers, as you brought up earlier, that are also providing services. And we're saying that the community needs to come in and help this behavioral health center meet some of its general obligations for for operations, but we're not requiring them, the community, to come in and help any other mental health provider meet the conditions of their requirement. And so it becomes kind of an obsolete requirement with the way the new structure is. I think that the folks, the behavioral health folks, will probably suggest that it's a great incentive if it's in statute to have the it's an incentive to the community to participate in having these services available, and we understand that, but it's just a little different model there that frankly is, in my estimations, kind of trying to put a round peg back in a square hole.
Chairman Scott?
Well, Madam Chairman, I think it still has quite a good deal to do with motivating them to stay involved in the community, to stay responsive, even dealing with the priority populations. Frankly, Madam Chairman, I have a reservation about this provision.
Madam Chairman.
Representative Larson?
Thank you, Madam Chairman. And Senator Scott, then if my question then would be to you is then what would we base that 10% of what?
Madam Chairman?
Chairman Scott?
I would think that you leave it right the way it is. 10% of the non-federal money. But you know, you could make an argument for doing something different. But that would be my recommendation, would be to just remove this from the repealer. And Madam Chairman, on 35-1-124, there's a provision in there for I think it's the basis for the sliding fee. Why is that being removed?
Chairman Scott, I couldn't hear clearly which component, which repealer, 35-1-624?
35-1-624, it's actually item 4 in there, Madam Chairman.
So that there, in order to contract with the department, a private agency shall have as its primary purpose the provision of human services programs, be chartered under the laws of the state of Wyoming, provide at least one human services program which serves the residents of at least one county, appoint a director whose qualifications meet the standards fixed by the division, charge client fees at a rate comparable to the uniform schedule of fees that have been promulgated by the division. Private agencies may charge a reasonable fee for those services not covered in the fee schedule. Okay.
Yeah, it's, Madam Chairman.
Chairman Scott.
Madam Chairman, it's the 0.5 that I'm really like sets the basis for the sliding fee scale, and maybe I'm misunderstanding something, but that's what it looks like.
Well, they did this bill previously, in the bill that we're looking at, does have on page 14 that they shall establish payment policies for state-funded services provided to priority populations that take into account a client's ability to pay. I guess what I'm seeing in 35-1-624-5, that evidently the division is supposed to promulgate a uniform schedule of fees. Well, I'm not sure. We may have to ask the department when they come up. Representative Larson.
Thank you, Madam Chairman. And and part of that really is if you go back and you look at the definition of a behavioral health center, we're establishing there in definitions that they're nationally accredited organization that's licensed to conduct business in the state of Wyoming. and provides a comprehensive range of services for the treatment and management of mental illness and substance use disorders for priority populations. And so in this 624 then becomes a little bit antiquated because it's saying that we have to go in and define not only for the priority populations, but for the rest of the clientele that they'll be serving, how they run their business. And I don't think, we just didn't feel that that was necessary anymore.
Okay, let's put a post-it there if you want it. Let's keep going. Mr. Brody.
Madam Chairman.
Yeah, Representative Barlow.
Madam Chairman, probably one of the more informative things to look at is 35-1-615. And these community boards are an agency of county government. And I think that's what the effort of the revisions are, to try to keep the state out of the county government's business as much as possible, only to impact it when there are state funds involved. And I think that, I hope that will give some clarity to why some of these, we're pulling back on some of these requirements, because we believe we want communities to have full authority over their own affairs. We only want to impact them when there's state general fund dollars and priorities in place. Thank you, Madam Chairman.
Very good. Okay, Mr. Brody, if you'll continue on, I believe we're starting with section 3.
Thank you, Madam Chairman. So as I kind of mentioned briefly at the beginning when I introduced the bill, this is kind of the second component whereby the Department of Health now in this upcoming interim needs to meet with the various stakeholders and discuss the policy that is defined in section 1 of the bill. So beginning on line 13, it directs the Department of Health to consult with affected mental illness and substance use disorder treatment providers and other stakeholder organizations, and basically discuss the reform and redesign of state-funded mental illness and substance use disorder treatment programs required under this bill. As part of that conversation, there's a number of factors that need to be taken into consideration. The first being eligibility requirements for the receipt of state funding consistent with the priority populations as articulated in the bill. The second condition is eligibility requirements for the receipt of essential subsidy payments, as I had previously discussed, to those behavioral health centers or providers that have otherwise been contracted with. And basically the Department of Health needs to kind of figure out the payment methodology and how you would qualify for this type of payment. Beginning on line 15, a pay-for-performance program methodology. In a nutshell, basically, the department will have to speak with all the various stakeholders and try to identify how to measure outcomes so that there's data for the legislature, for the Department of Health to understand if the system is working, if it needs to be tweaked, whatever the case may be. And some of those, I guess, levels or things that you could judge by would be the prevention of a psychiatric hospitalization, the prevention of reincarceration in an institution or other penal institution, whether or not they have competitive employment in an integrated setting, as those terms are defined in Title IX, and whether or not they have independent housing. Beginning on line 14, they would also have to look into the implementation of a case management process. This provision is the result of the joint subcommittee's brainstorming that case management was an important part of what the behavioral health centers were going to have to do so that they could keep a line on all the folks that are receiving services and understand what services they need and potentially direct them to the services that are required. So the department and the stakeholders would have to look into implementing a case management process in that respect. They would have to look at the delivery of housing and crisis shelter assistance priority populations. So in any case, when it comes to all those 5 priority populations, if there's housing and other types of assistance, that should be part of the discussion that's occurring as well. Beginning on line 1, page 23, on or before July 31st of 2021, the Department of Health has to report to the Joint Subcommittee basically on the results of its discussions, its findings, and any recommendations that have been generated as a result of this consultation. As part of that, it will also need to look at what funds can be repurposed to best implement the policies that are put forward in this bill. This is basically just a cue to the department to examine a number of different funding units within their budget. We highlight 4 in this bill, but they can look at others to see what funds maybe would be better repurposed for the community mental health centers that are currently being directed to another area of Department of Health's jurisdiction. Page 23, line 21. This is just the ability for the Department of Health and the Department of Family Services to promulgate any rules that may be required under this bill. As you recall, the Department of Family Services has a fairly discrete rulemaking responsibility when it comes to families at high risk and defining kind of other family members that may receive services from a behavioral health center. So this gives them the authority to go ahead and get those rules going. And then, as I also mentioned, this bill has a 1-year delayed effective date, July 1st of 2022. This allows for all those stakeholder conversations to occur, for the Department of Health to report back to this committee, and then for this committee to take any appropriate action, any action it deems appropriate prior to any of the policy changes that are part of this bill going into effect. Madam Chairman, that's the bill, and I'm happy to answer any questions.
Questions for Mr. Brody? Oh, come. Surely there must be some questions. We haven't used them all up. Perhaps we have questions for Representative Larson, who has faithfully stayed at his post well beyond 3 o'clock. Representative Clem.
Yeah, thank you, Madam Chairman. So, yeah, I did write some other things down, try not to bog down the meeting. Back to page 7 on this bill, which I think were definitions. I think I understand the intent of the legislation, and I appreciate really the vision of it. So this has to do with referral from DFS. I had page 7, it looks like, and line 17 through 21. So this was, okay, going back to who has been referred to a behavioral health center by the Department of Family Services for treatment for mental health illness or a substance use disorder. And perhaps maybe DFS could speak to this more. I mean, typically I just wonder if the semantics are quite right. DFS isn't necessarily the one who refers. They will refer, for instance, a substance use disorder, or an adolescent substance use disorder, or use survey, or I can't think of the name of it. And then based upon those surveys and whatnot, you know, is kind of the determining factor of the action that is taken then. And so I just don't know if the language is quite right. I mean, should it be more? I'm not sure how to correct that, or if it needs correcting. Perhaps that is the language that's used in elsewhere in statute, and we all know what that means. I guess that's where I'm just a little hung up. It's not TFS. So, you know, if a child that had no, you know, could they be referred to one of these places without any kind of other underlying survey or assessment that says that they actually need those services, and hence would be a tier 1. Anyway, that's kind of where I'm going. Thanks.
So Representative Clem, if I can, so I for me, it's somewhat easier to think of, you know, example children. But so I guess you're thinking of a child, you know, who's maybe exhibiting some challenging behaviors, and the family would like to get some counseling for the child because maybe he's been suspended from school for a week for doing whatever. And in this case, it's not severe enough to, I'm looking at the top of page 8, to have to prevent the removal of the child from the home or reunify the child. And in fact, the child may not even be in any way involved from DFS. Now, the thing is, of course, is that there's the facility may certainly treat this child whether through some pro bono thing, or if the child's on Medicaid or has insurance, that doesn't prevent the child from going there. But you're right, if a person who has insurance or is on Medicaid and could go to a different provider would not necessarily be on the top of their list. I mean, is that kind of what you're getting at? And I think I saw Representative Barlow first. I'll go through, but is that what you're sort of aiming at? Those children?
No, not quite. Yeah, I'm just thinking of how these referrals actually happen in real life. So let's say you have a person who's on a CHINS petition. They've been court ordered into DFS. You're trying to keep the kid from being removed into the home, from being removed from the home. They have some underlying mental health issues. Perhaps it's some kind of co-occurring disorder. So how is DFS going to go about making an informed decision? Well, they're going to go out and have the child and or family, the child's going to go through some kind of an assessment, right? Some kind of mental health assessment, or perhaps a substance abuse assessment. And then based upon that assessment itself is going to make the referral. That assessment, the outcome of the assessment is going to say that this child is, has X, Y, or Z, and this is what the treatment should be. That's the referral. So I just look at the paragraph and I'm thinking, okay, it says that DFS is going to be the one that makes the referral, when in all reality, in the practical sense of things, it's not necessarily DFS that's making the referral. It's the assessment that's making the referral. And again, I think we all know what it means, or what we're trying to get at here on page 7 in that paragraph B in line 17 through 22. I just don't know. And perhaps that's how statute elsewhere deals with this. I just don't know. I'm just trying to think this through.
Right. It's almost like you're saying for
mean.
diagnosis or treatment. Let me just pick up a couple of these questions here. Representative Barlow, did you have some input here? I think I saw your hand. No. Okay. Representative Larson.
Madam Chairman, and I think one of the important points to be here is it really allows, so we're now accessing a second pot of money for the Department of Family Services. They don't have to make a referral for diagnosis, or they can make the referral to get a diagnosis to whomever they feel is the most appropriate, and that may be a private provider that does that they would pay for out of their pot of money, but then they may then refer based on that diagnosis to a behavioral health center, just to capitalize on additional funds that are now available to them to help and provided through these behavioral health centers. So they kind of have a second way of accessing some services to these families for these mental health services. But I think the representative is correct that I know he's correct that there's assessments that will be made, but how those assessments are paid for and may not necessarily come through the behavioral through this funding. It would come through the traditional budget of DFS, and then that plays out. And I don't know, as we worked with DFS on this language, we were just trying to capture with them how we get this population that's not already been adjudicated, and we're trying to prevent any type of judicial involvement. How we are they a priority? And again, it comes back to the Family First Act and trying to implement some of that practices there to keep families together. And so that's why we move this up into a tier 1 or priority 1.
Okay, let's I think maybe we want to have a couple more run-throughs on questions, and then I think what we'll have to, we will really, because this is our last meeting. If we want to sponsor this, if we've got easy amendments, I think we can make them. If we have a little bit more substantive amendments, my personal recommendation would be that we go ahead and move this forward so that we have the bill draft. And if we can straighten it out a little bit more as we think, it's a pretty significant piece of paper here. But as we look at them a little bit more, as we continue to get input, personally, I would rather give ourselves something to move forward with. I don't think it's really, I don't know that we really have the capability to, amend 50% of the bill kind of on the fly on a Zoom meeting here. I mean, if necessary, I did book tomorrow if we want to draft amendments overnight and bring them in. But I think we might be a little more successful with that if we could actually have this put forward and carry. That's just my Mr. Brody.
Thank you, Madam Chairman. I would just add that we do have a representative from the Department of Health in the waiting room who could potentially answer some questions. And then I'd just like to note that we do have a handful of individuals that have signed up to provide public comment.
Yes, very good. So I've not taken a motion or anything on the bill, but I just want to go through and make sure now that everyone's gone, now that we've gotten to the end of the bill, let's go back to the beginning, just mark out, really identify if you've got Post-its or bend the corners or whatever, where the questions are, so we can try to be kind of coherent on our questions when we talk to the people testifying. Representative Larson.
Madam Chairman, just didn't know if you had seen Representative Stivar's been.
I did not. You should tilt your camera, Representative Stivar. All I really see is the top of your head. Very fine head is too. What was your question, Representative Stivar?
Question I have, Madam Chairman, is the definitions of mental illness as you go through this, they're different, and it doesn't make sense to me. Somebody that says on page 2, behavior disorder which causes a person to be dangerous to himself or others, which requires treatment. Just because somebody's not a danger to himself or others, they still can have a mental illness.
Right, but remember, that's the one on page 2 is the one in Title 25. So it's would be specific to that title, not necessarily the whole philosophical world of mental illness. But when does a person's mental illness put them into the purview of Title 25? I think that would be probably the answer to that question. Okay, let's just go and again, guys, we let's start off on page 2 and 3. We've got the Title 25 definitions. Does there anyone, Representative Barlow was raising his hand.
Madam Chairman, I just want to be clear. Are you going to work the bill now or take more public comment?
No, I am going to take more public comment. Yeah, I'm going to hear them all. I just wanted for us, because we had a lot of questions that really came up throughout the bill, and some of them we asked before we got to the end. I just wanted to kind of go back to the beginning here and just really hear so that I can mark, okay, where are the big question areas, so that when we take testimony, we're not quite so scattered. We'll have really pinned it down to, a few questions. So if there is there anybody really with the questions on the Title 25 part? Representative Clem.
Thank you, Madam Chairman. I'm really just kind of waiting for the department representative to testify, and I'll probably ask questions then. I guess I just have more questions again around this co-occurring disorder language, not only found in Title 25, but then also in Title 35, in how that plays out. And so hopefully that representative from the Department of Health can hear these. That's really where I'm zeroed in on, because I just think of it again in practical terms. So you have let's say a child who has a co-occurring disorder. They've been diagnosed with major depressive disorder and substance use disorder, and it's a co-occurring disorder. So let's say they go to some kind of treatment or something. They're in a tier 1, and all of this, they go to a behavioral health center, and they're being treated for major depressive disorder. And let's say that treatment is successful, and they no longer meet the criteria for major depressive disorder, but they're still struggling with the substance use disorder, because that was used in conjunction. It was a co-occurring disorder. And I'm just wondering then, are they bumped off of the priority list, and then are kind of left to fend for themselves? Does the treatment change? I mean, a provider wouldn't do that and leave someone out in the dark like that, but I'm just trying to is that going to be something that the family's going to have to come up with then and manage? Those are things that are just going through my mind, and how that all works.
Okay,
Preferably, and I'll probably make an amendment to have that co-occurring disorder language put back in there. But that's what I want to hear about.
Okay, let's put a post-it there. All right, pages 4 and 5. Let's see. Representative Larson.
I just got a note from Director Schmidt that she'd be happy to be available if we could get LSO to.
I think that would be really helpful. Also, would you have Director Schmidt lined up as well? Chairman Scott.
Madam Chairman, I would say that I share Representative Clem's concerns on this one, but my concern's a little bit different. I'm afraid, I think I understand what the committee is trying to do. I'm afraid there may be unintended consequences with how other people may read what we've done here. And then on the next section on page 3, you have this behavioral health center definition used. And all through this, I have a concern that we're making a fundamental change here where some communities just don't do it that way, and we're going to get ourselves in trouble. I see the contracting provisions on page 14, but as it's used here and a number of other places, that isn't cured by the contracting provisions, and I think we may have a problem.
Okay, so we'll bring that up as a question. Pages 4 and 5, we've got that was really just changing substance abuse to use disorder. The bottom of page 6, I think just the question about the adults with acute mental illness. I understand that the definition is just for purpose of this act. I'm a little bit challenged by the wording on that. Have I left anyone behind? Any other questions? I'm up through page 7. I'm just wanting to make a list of questions so that we make sure to address them. Was there someone?
Madam Chairman,
Scott.
yeah, and again, I've got bandwidth problems, so I lost the video. But that provision on the bottom of page 6, I remain quite concerned the way that definition is used later on, that we are we're forcing people to get in some kind of trouble with either the law or Title 25 before they can make the priority list, and cutting out people who come forth voluntarily, maybe because they've had family pressure to do so, but for whatever reason, they come forth voluntarily, they don't make the priority list.
Right, I understand. So that's on my list. Okay, bottom of pages 8 and 9, we've got the definitions of general access, the 2 types of indigence, and then the non-state level justice involved. Any issues there, Mr. Brody?
Madam Chairman, thank you. I would just raise one small housekeeping point, and that's on page 7, line 11, or excuse me, line 14, and then compare that to page 7, lines 17 and 18. This was it's perhaps an inconsistency. This was identified by Representative Barlow during one of the working group sessions, but it may be advisable to add child or the parent, legal guardian, or other to line 14 in order to make that language consistent and applied equally when it comes to those 2 types of categories.
Good. Okay, I'm marking that down. Page 7. Lines 14 through 17. Okay, we'll address that when we come to it. Okay, so all the way through 9 is and one thing that I will just bring up is throughout we have the 6-month time period. We'll want to give some thought to whether that's a good measure, whether we want a year or whatever. Remember, it's not the time period for which they can access services. It's just saying that if the person has been discharged or whatever the word is in criminal situation, discharged within the last 6 months, then they're on this list. If you've already been out for a year, then you don't fall into the priority. We may want to discuss that. Chairman Scott.
Madam Chairman, and specifically on that 6 months provision, it might be appropriate for trying to get priority services to criminals or other inmates that have, inmates, I guess be the right term, that have been released, and you want to get them services promptly. I wonder where it's used with people that have been involuntarily committed, or sometimes whether a 2-year period might be more appropriate, because some of these situations, we see them recurring, but it isn't always within 6 months. And that's one I'm uncertain about.
That's true. Although we hear about the warm handoff, so hopefully they're brought in and given their case number, so to speak, and then they get to stay there, we hope. But okay, picking up on 10, we've just got the definition of the state level justice involved. Any questions there? Okay, then 11 and 12 is just the reinsertion of the rephrasing of mental health centers. Page 12, we pick up on powers of the department. Page 14, we've got payment policies, and then the prioritization. Okay, anybody here? Just I don't want to lose anybody, but of course I'm looking at my paper while I'm talking. Okay, page 15, of course, is the arrangement of the tiers. Page 15, starting on line 15, is the language about the essential subsidy payments to defer continuous operating costs at other places. And page 16, the 35-mile radius. Page 16, line 11, is the prioritization of the behavioral health centers for the delivery of gatekeeping services. I think I had heard a question about that before. Or do we want to? I'm just keeping a list for now. Nothing at present. Okay. Then we have a number of payments that are just really cleanups. Okay, page 20, we have the repealers. Then section 3, we've got the assignment to basically continue thinking about it, which is certainly good. Eligibility requirements for the various things, the pay performance program, the implementation of the case management system, and the repurposing. I'm not sure how much we need to really work that over this time. That's pretty easily amended in committee if we want to, but okay, so those are that's the question list that I have to make sure that we hear from people, is the issue of the co-occurring, whether that can be deleted from the mental illness definition. Page 3, just the change to the behavioral health center issue as far as prioritization. Page 6, the definition of adults with acute mental illness. Page 7, the family definition, and then the 6 months. That's what I heard and wrote down. That doesn't mean you can't ask some other questions, but just so that we can kind of keep ourselves going here a little bit, that's the list. Okay. So let's hear from public comment. Let's start with the Department of Health. Or Director Schmidt, are you on a time crunch? Do you want to talk first, just because you haven't been here all day?
Thank you, Madam Chairwoman. No, I'm fine. I'm not on a time crunch. So
okay, well then we'll let the Department of Health talk, because they've been so faithful and just live with us, glued to our hip, and every firing of every synapse. Looks like Mr. Johansson is ready to talk to us.
Thank you,
Mr.
Madam
Johansson.
Chairman, members of the committee, Stephen Johansson with the Department of Health. Good discussion on this bill. I just want to say as a brief introduction that the Department of Health is supportive of this effort. But it is important to acknowledge this would represent a fundamental policy change for the state of Wyoming, as Chairman Larson mentioned in his overview. This really comes down to the ability for the department, the direction to the department, to design a system that prioritizes a few types of clients. And again, you'll notice that these definitions of the populations are not necessarily clinical. That mimics the work of the facilities task force years ago, where this is really about the state policy directing the executive branch of what to implement, and in this case, who to prioritize for general fund services. So essentially, just to recap some of the things that were mentioned and give you some comments from the department's perspective, this would create a system where the clients that you see in those definitions, whether it's the justice involved, the high needs families or families at high risk, acute mentally ill, those categorical definitions would be prioritized. Essentially, those folks would be eligible for some sort of state general fund support through these behavioral health centers. The other category would be the indigent. That's where the income and the federal poverty level come into play. So the reason I kind of rehash that is because that's the fundamental policy change, is that in order to prioritize services in a system like this, it really necessitates kind of ruling out types of populations that are not priorities. And I know that sounds horrible and nobody wants to be in that position, but that's essentially the policy question that fortunately the Department of Health as an executive branch agency doesn't have to answer, but the legislature certainly would have to grapple with if this moves forward. We do think at the department a bill like this would help us design a system and give the appropriate direction, not only to us, but to our contractors and providers, of what the intent of the state is. And the reason I bring that up, Madam Chairman, is because the current system that we have, there are most definitely pros and cons of general access funding and of numerous kind of directions to provider groups of who to serve. And in my opinion, that's what we have a little bit of now in the community mental health and substance abuse system, is a lot of different priority populations. This flips that a little bit and has us truly prioritize those categorical definitions, as well as the indigent population that does not have access to a pay source like private insurance or Medicaid, or whatever pay source might be available. So happy to answer any questions from the Department of Health's perspective. Just wanted to give those comments that we are supportive of this bill, but certainly acknowledge that it's a big policy change, but one that we do think would have the potential to generate better outcomes for the populations that you see mentioned here, and truly allow us to target and prioritize those state dollars in some pretty difficult budget times. Thank you, Madam Chairman.
Okay, so what I'm going to do is kind of go through the list that I have collected, and then certainly other members of the committee may ask, but this way it will at least maybe get it a little bit focused. And Mr. Johansson, it's possible that you may not have an opinion on all the questions. That's okay. So I'm sure you were following along. First of all, on the bottom of page 2 and picking up on page 3, where the bill deletes the reference to except, so in other words, mental illness means such and such, except when alcohol or drug abuse co-occurs. Were you folks involved in any part of that discussion?
Madam Chairman, yes, briefly with the subcommittee and some of the other stakeholders. I think, as Representative Larson mentioned, this is truly a definitional issue. And I think the intent here, as you had mentioned before, Madam Chairman, this is Title 25. So the operative principle here is legal language that allows a county or a court to emergently detain or involuntarily hospitalize a person, essentially removing civil rights. That's again, the operative principle of the definition of mental illness here, is something that causes harm to self or others, which would necessitate protecting the person or protecting the community. In terms of the language that's been stricken on the top of page 3, again, I think it it assumes in the definition here that the mental illness definition is not supposed to be primarily alcohol or developmental disabilities. So I don't think the department would have a huge issue if that language were to remain in place, noting that a secondary diagnosis of DD or a comorbidity, a co-occurring condition could be part of somebody's needs, but their primary reason for going through Title 25 would be the mental illness that's manifesting in behaviors that are dangerous to themselves or others. So not a huge opinion there, Madam Chairman.
Okay, and then on page 3, and Chairman Scott, you may want to pitch in on this, but there was just a general discussion about prioritizing behavioral health centers as the gatekeeper, and I think that, Chairman Scott, that was your question here, and whether we really, I think the addition of this paragraph, I think, was a late arrival in the draft. I'm not really sure. Was that, Chairman Scott, did I articulate, am I on the right place with this, with your concern here?
Madam Chairman, that was one of the concerns I had here, yes.
Mr. Johansson, any thoughts there?
Madam Chairman and Co-Chairman Scott, it's a good question. I think from my perspective, there might be some conflation with what prioritize means here with what it means in the latter parts of the bill with the actual priority populations. Potentially the intent here, and I won't speak for the subcommittee, would be to give preference to a behavioral health center. And when we say behavioral health centers right now, that would, in the current condition, that would be a community mental health or substance abuse center. They're essentially being renamed in this bill. To the discussion earlier, Madam Chairman, about the department's priorities or preferences when it comes to gatekeeping, I think the Title 25 statute that was amended several years ago did assume or intend that the department would consider community mental health centers to be gatekeepers. That's essentially the infrastructure that we fund in the communities, and certainly an intent that we have to use that infrastructure to provide Title 25 gatekeeping, care coordination services, case management services. And so when we talk about the department prioritizing these behavioral health centers, it's essentially the same idea. I don't think it creates a discriminatory condition with these centers that if they don't provide this, then they don't get something else. To Chairman Scott's, Co-Chairman Scott's point, but there are communities, I believe 1 or 2 currently, that do not use a community mental health center for their gatekeeper. Now they do rely on community mental health centers for services, but I'm thinking of Albany County, who in the past had used a private provider because that person or that entity, they wanted to provide a person to show up to hearings under Title 25, et cetera, and maybe refer to the community mental health center, but not use the actual mental health center. But long answer, now I'll sum it up, Madam Chairman, is I think the idea here would be under Title 25, the direction to the department would be to give preference to these behavioral health centers to provide a level of service to Title 25 clientele like gatekeeping, something the department certainly doesn't have a problem with. And we don't think that would create a perverse incentive one way or the other for other providers.
I think we do have, we will be expecting testimony later from, I think, community providers. But so, Mr. Johansson, would you anticipate that this language would cause you to change in some counties who you are funding or who the county is funding for gatekeeping services?
Madam Chairman, probably not. Given what Representative Barlow mentioned earlier is very important here, that the Title 25 statute that's not shown here in this bill requires the department to consult with the county commission before making a gatekeeper designation. So the way that we handle that is the department may seek to designate a gatekeeper under Title 25, but we solicit input, feedback, et cetera, from the county commission on their preferences. And that kind of kicks off a stakeholder engagement process at the local level, which is why in the past several years we have worked with counties who might look to designate a gatekeeper that isn't a community mental health center, or in this case, what would be defined as a behavioral health center. So I don't think this would generate major changes to that process. This just gives us some language that we, again, should give preference to these behavioral health centers, as the intent of what the state policymakers, the legislature, wants that system to focus on does include Title 25 clients.
Okay, on page 6, beginning on line 16, we have the definition of adults with acute mental illness. And here, that definition, for purposes of this bill, basically means people who are have some sort of criminal or involuntary commitment component. It seems to exclude, people who are just in, cycling through schizophrenia and challenges with their meds, unless they would fall. I mean, and those people then would fall into the tier 2 of indigent high needs, probably. I mean, unless they're indigent, in which they're not a priority at all. What kind of discussion have you folks had on this issue?
And Madam Chairman, that's I appreciate that question. That's the reason I gave my soliloquy at the beginning about this policy change, is for that exact question. And you and Chairman Scott and Representative Clem bring up a good question of why does this prioritize folks or require folks to go through a legal system who might have more significant mental health or behavioral health issues prior to getting treatment at one of our community centers. And you just hit the nail on the head. This is really the fundamental policy change. Is this would be kind of an adjudicated person, for lack of a better term, someone who has had an acute mental illness incident that put them through Title 25, received an emergency detention and involuntary hospitalization, which would put them into this tier. The behavioral health centers would not be precluded from serving someone with serious mental illness who hadn't been adjudicated through a legal system. But with the state general fund dollars, this would necessitate that they did not have access to a pay source like private insurance. So again, that is really, it's a big policy change. Again, in our budget times and with the populations that the department is noticing are slipping through the cracks more and more with our corrections population, our Title 25 population, and our difficulty in placing some high needs children or finding wraparound services, more intensive services. The department does think this could work, but it's very important for us to point out that this would be a very different eligibility system under this proposed scheme, one that again we are supportive of and think we can make it work. But that's essentially, Madam Chairman, what you had mentioned. It would put that person into the if they were low income without a pay source for those services, then that they would certainly qualify for eligibility under this.
Right. So just to rephrase, so a person with a fairly severe mental illness, many people needing case management. If the person, say, has qualified for disability, so they, on Medicare and Medicaid through SSI, then they could, of course, go to any provider around, assuming that there are some. And if they're indigent, then they will fall into tier 2. But really a person who is an adult with a severe mental illness, who has disability or insurance, or maybe is uninsured but just not indigent, we're pretty much saying that those people should access private providers. And I'm not saying that that's a bad thing. We have perfectly good private providers. That's not necessarily bad, but that is, we want to make sure we're clear on that. And as I said, You know, I mean, I struggle with that a little bit, but at the other hand, if we put if everyone is a priority, then no one is a priority, and then appropriations will likely make their own priority list, which might not be our priority list. So I just remind myself of that. Okay, picking up on page 7.
And Madam Chairman, can I make one clarification to that point? That you're right. The one clarification I would make is for someone who would not fall into an indigent category, but might have a serious mental illness and wouldn't be defined as, you know, indigent for lack of a better term. It's not that these behavioral health centers could not provide services. Right. It's just the pay source would have to be different.
Right. They're not a priority for the general fund expenditure.
Correct.
Fair enough.
Correct.
Okay. Page 7, we had Mr. Brody brought up the question about inserting. Do you have anything to comment on the family issue? I think that's just a cleanup, really. Were you following that, Mr. Johansson?
Madam Chairman, I was trying the best I could to follow. I'm not entirely sure what the issue or question.
The question was just on page 7, paragraph A, line 14 just says the children and their immediate family members. And then paragraph B says a child or the parent, legal guardian, or other immediate. I mean, the thought was that we should just make those the same parent, children who have so-and-so and or the parent, legal guardian, or other immediate family member. In other words, using the same family language in both paragraphs. Is that
Madam Chairman, I might defer to Director Schmidt on that for the best operative language.
All right,
I think
we'll pick that up.
From the health department's perspective, the idea here with this category would be that this population, whether it's the children or the families, would be, you know, a priority that could receive services from a behavioral health center with the Department of Health's general fund dollars.
Right. Director Schmidt, if you're there somewhere on my little screen, if you'll just look at page 7 while we're still talking with the Department of Health, I believe you probably heard our discussion on making the family member language on line 14 and on line 17 and 18 match. Just give that some thought before we show up with you. Okay, then Mr. Johansson, just in general, the discussion of whether 6 months is the right time period or whether we should go for a year, or do you folks have any input on that?
Madam Chairman, we had lengthy discussions with Chairman Larson, the work group, the subcommittee, the stakeholders on what is the most appropriate. Again, this is not clinical. This is more around eligibility. This is more around operations. So as Chairman Larson had indicated before, this doesn't mean that a person's treatment, if they were adjudicated under Title 25 or in the correction system 2 months ago, has to stop, you know, at the 6-month mark. I don't know what the best look back period would be. I think it causes us to consider, again, this is about prioritizing resources and trying to get the most services for those most in need and the best outcomes. Whether that would be increased to a year or more, we'd be willing, certainly at the table, to entertain those discussions, but this is more about a cut point of when an eligibility system could look back.
Okay. All right. That was the list that I gathered together from what people's input. Does anyone have any other questions for Mr. Johansson? Representative Yin.
Thank you, Madam Chairman, and I apologize for not getting this on the list before we had testimony. However, Mr. Johansson, I'm slightly concerned with our the 100% number, and I remember during the initial testimony that there was talk about there's a reason that it's 100%, but you know, given my Teton County population, we have really excessively high rents, and so there are people who make above 100% of the poverty line. However, if the choice becomes paying their rent versus paying for some mental health services, I assume that paying rent is going to win every time. So I wonder is there any sort of data on the numbers of people who take advantage of that service that would not be able to take advantage of the service if we have this 100% poverty line number in here?
Mr. Johansson.
Madam Chairman, Representative Yin, good question. Again, a little bit of a distinction there between folks in this proposed bill draft who would be over 100% of the poverty level would not necessarily then have to pay for mental health services, but it would necessitate the mental health provider, the behavioral health center, trying to leverage an additional pay source, an insurance plan, for example. So the reason this came up and has come up in a lot of our other programs in the Department of Health, primarily in Medicaid, is because of the advent of the subsidized health insurance that is available on the marketplace. I will mention that under the current administration a couple of years ago, a part of those subsidies were removed. The cost sharing reduction subsidies that were available before, which increased the actuarial value of plans, have gone away. But the general advanced premium tax credits, as they're called, so the major subsidy for private insurance on the marketplace for folks above 100% of the poverty level, are still certainly in place. So Representative Yen, your point is well taken, but I want to make it clear that the way we read this bill language, it would not prevent somebody from receiving services. It would just require that an alternative pay source would have to be available. The policy question for this committee or the legislature in general is that appropriate? Should that be 100%? Should that be 150? Should that be unlimited? I mean, that's where this fundamental and philosophical policy decision between general access and a more prioritized eligibility system comes into play.
Chairman Scott.
Madam Chairman, let me give you a different answer on that question. The 100%, if you're under that, you're ineligible for the subsidized care through the exchanges. If you're at 100%, you can get that subsidized care. Under current circumstances, a majority of the offerings there are without premium. And my understanding is they still at the lower reaches of the poverty level, above 100%, but not too far above, the insurance company eats the deductibles, can't change the deductibles. That's still, I believe, the law, and the way it's worked in Wyoming. It may change, but right now, nobody's going to have to make a choice between paying the rent and getting mental health services. All they've got to do is get a free policy through the exchange. And that makes, in current economic situation, that makes this a very relevant number. It's something we might want to revisit in a year or two if they change the law in Washington, or if they put a stop to the way we've been able to work their system with doing what's called silver loading and get so many of the policies to be free. But under current circumstances, this makes a lot of sense given the way the feds operate with the policies through the exchanges. And basically it says we're going to rely on the federal government to pay this one.
More questions for Mr. Johansson? Okay, very good. Who else have we been? Thank you, Mr. Johansson. Let's ask Director Schmidt to step in.
Hello, Madam Chairwoman, members of the committee.
Good to see you. Thank you. So I'm going to, do you have any basic comments on this before I plunge into my question list?
Madam Chairwoman, no, I'll let you get into your list so that I make sure that I capture everything. I tried to capture as many of Representative Clem's questions, but I'm not sure if I got all of them, so it'd be helpful if you maybe.
Okay, I'll go through and then we'll circle back. So,
Okay.
and some of these we've heard, but I just, because you have, see a lot of these clients in a slightly different way. So at the bottom of page 2 and the top of 3, this was under the Title 25 definitions about taking out the language on the co-occurring. Did you have any input on that? Not really.
Madam Chairwoman, no, I don't have any comments on that. I'll defer the Title 25 issues back to the Department of Health and to the committee unless it's otherwise specifically mentioning children, which are in Title 25, but not part of this conversation.
Okay, then I'll skip the page 3 question. Okay, page 6. Well, and actually, again, if it's adults, it's probably not you, right?
Correct.
Okay, well, we'll skip that one then. Any thought in general? Oh wait, no. On page 7, so there was the suggestion from LSO that maybe we might want to have the language on family members be the same in paragraph A and B. Did you have any thought on that?
Madam Chairwoman, no, I think to make them consistent with each other is fine. During the original conversation, it was the two definitions, we kind of discussed them separately, but looking at them together, it makes sense that you could refer to both the same.
So I would hypothesize that whether we say children and their immediate family members as defined by rule, that you could include legal guardian in there just as well, or we've got the choice of the child or the parent, legal guardian, or other immediate family member as defined by rule. Is there any difference between, do you have a preference?
Madam Chairwoman, I would prefer the latter, the definition that comes with the DFS referral of children and families, so it's more consistent. And to speak a little bit more to that, the federal government defines family fairly broadly, but it can also change to include kinship and other types of caregivers. It really comes down to who's in the child's world and who's the main primary caregiver. And it's not always family. It's not always biological family. So the flexibility there for us to establish it by rule will then allow us to keep up with any federal government changes in terms of their federal language. So it just makes it more flexible.
Okay, I will pick up here and just because I'm on page 7, and Representative Clem, I'll call upon you then, but the question was brought up as to whether the explanation in, I believe it was just paragraph B, but about the referral of a child to a behavioral health center for treatment, is that the best way to phrase that? And Representative Clem, if you want to flesh that out a little bit, feel free.
Yeah, thank you, Madam Chairman. I think Director Schmidt has knows what I'm getting at there. If not, I can explain further.
Director Schmidt, what your thoughts?
Madam Chairman and Representative Clem, I think what the key word that we're thinking about is the word treatment, correct? And so going back to Representative Clem's testimony, that oftentimes there's assessments, there's a lot of things that happen before treatment is actually given. And so services may be a better way to categorize, and I didn't catch that, but in this conversation, referring to services may be more appropriate, because community mental health and substance abuse centers, now called behavioral health centers, do provide a larger array of services than just treatment. They do assessments, they do case management, they do other things. The basic intent for us in terms of being a priority population in regard to this legislation really comes down to the fact that when we engage with a family, perhaps before there's been adjudication, so if there's an allegation or a report of abuse and neglect of a child, and a call is made to us, we can go out and engage with the family and offer to volunteer services to work with them. So a family may engage with us voluntarily. And what we would do, and a lot of times, is then refer parents maybe to a community mental health or substance abuse center for a substance abuse evaluation or mental health services. And we can engage with that family that way, so that those services can be provided, so that the issue doesn't escalate to a point where we then have to remove. Because once then we have to remove, then there's the court situation gets involved, and then the case becomes much more complicated. So the idea that those families then, if they go to a behavioral health center per our referral, and then they're now part of the priority population, then what that says is this family is really important. We want to prevent further issue, whatever is that the issue is that came to our attention, and get them engaged in services, whether that is an assessment, perhaps then follow-up treatment, or whatever it is that that center happens to provide. So that's why it's important on the front end before adjudication. On the back end then, when a child is adjudicated, whether it's the CHINS child like Representative Clem mentioned, or delinquent, or in what we're thinking primarily is abuse and neglect, that child comes into the care of the state and is eligible then for Medicaid. So whatever mental health services that child receives at that point, Medicaid will be the payer. However, the family is still not accessing services. And the department, our Department of Family Services, has always relied on those behavioral health contracts to serve our parents who otherwise may not have a funding source, whether that's private pay or insurance, and then take advantage of the state general fund services on the sliding fee scale. So we don't have additional dollars to serve the adults because we've always relied on the Department of Health contracts with the community mental health centers to do that. What this says is that we would like to have some level of priority because the children are in custody, the parents really need help. We want to reunify the family when possible. And in order to do that, it really does sometimes come down to mental health and substance abuse services solely. So that's the, oh, I'm sorry.
No, I was just going to say, so Director Schmidt, just looking at that paragraph B, I have two questions. One is the placement of the word services is a little bit awkward, but if we pick up at the end of line 20, by the Department of Family Services for services for a mental illness, I mean, because then we got the word services twice in 1 inch, but deleting treatment. Another, then, so that's one out, and we're not making the amendment now, committee. I'm just kind of trying to clear it all up while everybody's here. My other question, though, is you talked about where the child might have been covered under Medicaid because of the case proceeding, but you still want services for the family. Now, if we turn this to say by the Department of Family Services for services for a mental illness or a substance use disorder, what the family really needs, I would suppose, is counseling. Now, the family members don't necessarily have mental illness or substance use disorder. So I'm wondering, do we want to say referred by the Department of Family Services for counseling or treatment for a mental illness or substance, or wait, no. Department of Family Services for counseling or services for a mental illness. You see what I'm saying? I'm just wondering if we say only services for mental illness or substance use disorder, maybe we've really left out the needs of the family member in that situation. Do you have any thoughts on that?
Madam Chairman, I'm trying to figure out, if I may, I'd like to step back maybe and tell you what we would like, and then the language could perhaps be crafted to follow that. Essentially, what we want is that when two families walk into a community mental health center for whatever reason, right? There may be an issue with the child, behavioral issues with the child, there may be substance abuse by the parent, there may be both. But when DFS gets involved, it's usually because of the child specifically, right? So that's where that center of attention comes. However, we also know in any one of those situations that it's often the family environment that really needs to be supported as well. So it could be that there's family treatment that needs to take place. There's as a whole. And sometimes when the child's in care of the state, Medicaid may pay for that. But if the child's not in the care of the state and the whole family needs services, then this provision would allow for that too. So I'm not sure how to tease out the difference between counseling and treatment, other than to say the community mental health and substance abuse centers, many of them have a tremendous amount of services and resources, not just treatment. And so we would like to access any one of those given services that may be helpful for that family.
Well, and that was kind of what I was getting at, is that if we just say services for a mental illness or a substance use disorder, does that leave out some of the potential needs of the family? I mean, let's just suppose the child is, has got, a behavioral problem, and then is taken into custody or whatever, but in order to get the child back home, the family needs some counseling on how to deal with their child, but the family members don't have particularly a mental illness or a substance use disorder. I mean, necessarily, I mean, they might, but so I'm just wondering, when we're trying to get the family, if we were to say referred for counseling or services for a mental illness or substance use disorder, would that make it broad enough to cover the needs of the family? You know, and maybe I've just spent too much time with social workers today. Do you see what I'm trying to get at? Or maybe I'm making it too broad. I mean, maybe Representative Larson has got this panicked feeling that Wilson's running away with the horse here. Representative Larson, you can speak.
Madam Chairman, you're doing just great.
Well, we can come back to that. But anyway, what was your thinking on Director Schmidt? And you can tell me, no, stop, whatever. We're not making an amendment now, but while you're here.
Madam Chairman, I think it's inherent in the way that it's already written, but if you feel that there's going to be some deliberate picking apart of the language, then adding, you know, a basic service category or counseling maybe.
That's fine. Okay, I won't spend a lot of time on it. How about the 6-month issue? Did you have any thoughts on that? Is that a good time period? You don't care really, or what?
Madam Chairwoman, no, I don't have any thoughts on that.
Okay, more questions for Director Schmidt? Some people look really like you're falling down. Come on, guys, it's only 4:45. Wake up. Yeah, this is the Labor Committee now. Representative Sweeney.
Thank you, Madam Chairman. So, Director, is what happens on somebody lives out in the boondocks and there's not a counseling center for miles and miles, or they're returned to a community? Does this bill allow any private counseling that we would contract with, or I hadn't really thought about it, but it just came to mind.
Director Schmidt.
Madam Chairman and Representative Sweeney, I may want to defer this a little bit to Mr. Johansson and Chairman Larson in regard to the language of the bill, but my understanding is that this particular legislation is really set up around the community mental health and substance abuse centers themselves. And so then with this new definition or this new label given to them called behavioral health centers. And the behavioral health centers are responsible for providing services within their service delivery location, which should include then the boondocks, right? Community mental health and substance abuse centers cover all of the counties. But I think what you're asking then is if they do not provide a service to some sort of location, then is there a payer source for a private provider to provide service to that person, whether it's a child or an adult? And right now, no, unless they're in the custody of DFS, or unless they're on Medicaid, or if they have a private payer system like insurance, I'm not familiar with another mechanism through the Department of Health and not through the Department of Family Services where you could pay for that directly.
Representative Larson.
Thank you, Madam Chairman, and Representative Sweeney. That's just a little bit of the inherent challenges we have in Wyoming with any type of healthcare delivery. Is we have some portion of our populations that live in Lost Cabin or Lance Creek or someplace that's a long way from a provider, and as I think we all understand, it becomes impractical to have, whether it be medical services or mental health services in every small town. And so as people elect or are forced to live in rural communities, my daughter lives in Cokeville, and when something they have if they need community mental health services, they have to go up into Star Valley to do that. That's just kind of inherent. that challenge exists in our current system, and we try in this as we prioritize this with this bill. That's why we have that component in there that we would provide a subsidy back to those rural providers where the behavioral health center may be the only source of mental health services in a rural community or rural county, to help them keep the doors open, because they may not generate enough revenue just off the priority population, or the general access clients that that walk through the door from those rural communities, but yet they play a critical part in providing those services to our population.
Thank you.
Did you have a follow-up, Mr. Representative Sweeney?
No, thank you.
Okay. Representative Clem?
Thank you, Madam Chairman. Kind of bigger picture with prioritizing. I guess in doing this policy shift and making a statement saying we're prioritizing these individuals, I guess who are we unprioritizing, if you will? What is the population, I guess, that is at risk of losing services, since we're prioritizing who's going to get services?
I was reading your lips. Was that me? Okay.
That's for anyone. Yeah, Representative Larson could touch on that, or anybody.
You're muted.
Yeah, fine. Thank you.
Thank you, Madam Chairman. You're muted.
Yeah,
there you
sorry.
go. So Representative Clemens, we talked about this in the whole scope of the subcommittee, and then as we were drafting the bill. You're exactly right, and it's repetitious of the discussion we had with the state health facilities. Should everyone who has a developmental disability be placed in the Wyoming Life Resource Center? And we made a policy change to say that was no, that we have community providers that can do it, and we, there's realm. And so then we take that same philosophy and we say, is it the state's responsibility to provide the mental health services to everybody? And we are coming back and saying no. And so then those that will not be getting services are perhaps those that that come in the door in maybe less of the sliding fee scale, those that have revenue sources, those that may that have insurance, but maybe for whatever reason weren't required to use that insurance. I think using that the scenario of 100% of the federal poverty level, as Chairman Scott pointed out, going from that 100 to 200 is a revenue stream that we just have not accessed before, because we just have left that up in this current system to fund those out of general funds. So I don't know that we can, so it would be those that perhaps have revenue resources that we haven't been using before, those that have access to insurance, and we've been and the insurance only reimburses part of that, and then they would cover the rest of it with the block grant. Some of those scenarios, and we're saying if they're not in that priority, that's probably not going to be possible. We can't make this adjustment without impacting some people.
Okay, Director Schmidt, I think we have asked all the questions of you. I don't see any other agency people, but we do have more people to testify. So I am just going to start at the top of the list. Renee Blair. Actually, Elisa, have you let them all in, or are you just going to let them in one at a time? Why don't you let in all?
Whatever you prefer. Would you like us to let them all in?
Yeah, why don't you just let all 6 of them in? 6 is what I see. Ms. Blair, I see you. We are going to call upon you. Welcome to the Labor Committee.
Okay.
What would you like to tell us? You're muted still. Oh, there you go. You muted again. There you go. Ms. Blair, would you like to tell us something about this bill?
Can't hear.
Ms. Blair, can you hear me okay?
Okay, I can hear you now.
Okay. What would you like to tell us about this bill?
Okay, I've studied it pretty good and I've been with you pretty much all day. So thank you for having me. First of all, I would like to tell you a little bit about me so you know where I'm coming from. I am a pharmacist of 23 years. I've gone to school and graduated from the University of Wyoming. I have worked for the VA, the IHS, retail, and mental health. I have worked pretty much across the board in every part of pharmacy there is. So I am coming from a very wealth of knowledge. I am disabled. I have worked, I was pharmacy for 23 years. I worked for 19 of that, and I was disabled with complex regional pain syndrome after my knee surgery, my total knee replacement. And I can't work anymore. So I am talking from both sides of the issue here. So I would like you to know that first of all. First thing I want to say is that your legislation, even though you are writing it from an eligibility standpoint, it will be read clinically. It will be read eligibility wise. It will be read whatever you are doing as a job, it will be read that way. I know that from experience. So beware of that, okay? When you say definitions for mental health or mental illness, if you're writing it legislatively, that's fine. But when I'm a pharmacist, I'm going to be reading your legislative stuff from a clinical standpoint. I also noticed that there's several things that you're constantly changing. You're changing your substance abuse to substance use. And that's fine, but we all know you're talking about substance abuse. Be aware of that, because that doesn't ever change just from a word. I wanted to say one thing I did notice in your bill here, and it was from when you guys talked about substance use disorder on the 25, it says that it does not include addiction. But then later on in your treatment, you switch to substance abuse.
Ms. Blair, what page are you looking at?
I'm looking at, here we go. I wrote it down here, but looking at page 14. And it says delivery of mental illness and substance abuse disorder services and human services programming. Is that intentional?
Okay, Ms. Blair, I'm not sure still what line you're on, but I will point out
I'm on line 19.
Okay, so just for your information, on page 2, Title 25 is just for the involuntary commitment. So the idea of the definition there is that we cannot involuntarily commit a person just because they are an alcoholic, let's say. I mean, they have to have, it has to fit into the mental illness. So that's why that definition is different than on page 14, which is in the Title 35 having to do with the mental health treatment centers.
Okay, we know that behavioral health centers and mental health centers include service or mental illness and substance use treatment, disorder treatment. But most addiction services are done through outpatient clinics and addiction specialty clinics. We know that. Because it takes a specialty type of a clinic to treat addiction. So I don't know if you guys have taken that into account. Addiction itself is not treated successfully through a behavioral health clinic, because addiction takes very specific. It takes the person have to want to deal with their addiction, and it usually takes more than just a couple of visits to a weekly visit to a doctor or a monthly visit to a doctor. And that is usually done on an outpatient or an inpatient basis to an actual addiction center. That's why they have decided to take addiction out of a comorbidity or with mental illness, because it can't be treated the same way and it has to be treated separately. So that's just something I don't know if you guys understood why the 25 took out the addiction and had mental illness be treated separately.
So speaking specifically to the issue of prioritization of populations in the community mental health centers, do you have any input on that? Just because it's getting late and I've got a list, so I want to make sure that
I have one thing to say about your mental or your substance use disorder, and that is, it has a lot to do with your indigent population. A lot of disabled people and a lot of your elderly population fall within those guidelines. And a lot of people, including myself, deal with chronic pain. That can be misconstrued as a substance use disorder. And it falls, and if it doesn't, and if you don't contact their doctors and verify that they are on chronic pain medications through a doctor, and you just assume they have a substance use disorder, I say they got a DUI and they got thrown in jail, and then you turn around and they get rerouted through the system, it happens, believe me, then they will be falsely oriented into a substance use disorder when they are actually on chronic pain medication for a valid reason. This is a very serious problem. It's being attacked from a lot of different angles, and people are losing their medications. They're automatically going into withdrawal, and therefore they are having a substance use disorder when they are, in reality, they are actually not at fault at all. They are actually being attacked for having chronic pain. And I really believe this is something that it needs to be addressed in your definition of substance use disorder. That needs to be validated before anybody is assumed to have a substance use disorder.
Very good input. Very good. I think that will certainly be passed on to the mental health professionals. Is there anyone with any questions for Ms. Blair? Okay, thanks very much, Ms. Blair. We appreciate your participation. Okay, next, Ms. Foland.
No, how do I get out? Let me out.
There. Thank you, Madam Chair, Mr. Co-Chair.
Ms. Foland.
Yes.
Welcome back. What have you got to tell us about LSO 225?
So I will be brief, looking at the late hour, and thank you for the opportunity to speak. One of the big things that pops up in most of this is that when we look at the state funding mechanisms, we also look at state regulations and the requirements. This particular bill is very concerning to those of us in private practice for a number of reasons. First and foremost is that there appears to be, for lack of better words, a monopoly in place by the mental health centers, the behavioral health centers under their new term. Many of us are not able to, because we're one person, staff of one, we're unable to meet the state's requirements for being a certified provider or being able to receive those referrals that we currently do now if the centers are going to be the priority and prioritized provider. And that's very disconcerting, especially in Carbon County, where our counseling center was just taken over by High Country Behavioral Health, but there are 2 licensed providers at that center right now. There are a total of 7 of us in the entire county. If they are going to be the gatekeeper of the Title 25 process, then that is also another problem. They will be the referral source and can enter into those contracts with DFS, with the school. Many of us will be relegated to only being able to take people who have private pay, either cash or third-party insurance. So I don't know if it's just in the language, and that's not what was intended, but the language makes it sound and does show that as very problematic in the smaller counties. Obviously, Natrona County, Laramie County, that have more resources can kind of spread things around. We don't have that opportunity here. It could potentially put some of us out of business if there's that monopoly that occurs where we're not able to receive those referrals, especially from the school district or DFS. When it comes to the Department of Health regulations, to be a certified provider to obtain state funds, this is the checklist. And most of us don't have the time to, or the money to put forth all the effort to get certified by the state. And this is to be able to do nothing, something as simple as an ASI. I'm not able to, although I am by license and education able to perform an ASI or a DVI, I'm not able to get reimbursement because I cannot take court-ordered clients for those services. So I encourage the committee to really take a look, and if it means that we step back and we gain more input from other than the community counseling centers, which seems to have been the primary source of information, and allow private practitioners like myself to be involved in those communications, I think we might all be able to come to an agreement on what this can look like. The other challenge is the subsidies. So now, as a private practice individual, I'm going to be subsidizing from my income, not necessarily my competitor, but the colleague. We've got some heartburn over that. And that, DFS has said that there is no other funding unless you're contracted through the counseling center. So that is problematic for many of us private practice providers. So with that being said, I just encourage the committee to, if we need to, put the brakes on, as Senator Bouchard and Representative Sweeney and Representative Clem have asked wonderful questions today in this aspect. And I would just encourage that we kind of slow down and make sure that we're making some of the right decisions, because this may cost the state a whole lot more money in the long run, that 3, 4, 5 years down the line, than it is right now trying to consolidate everything. And with that, I stand for questions.
Chairman Scott.
Madam Chairman, did I understand you rightly to say that you read this bill as saying that you couldn't take court-ordered patients? And if so, where does it say that? I didn't find that.
Ms. Folland.
Madam Chair, Mr. Co-Chair, Senator Scott. So it does refer in the section of public funding, and it's through the department's promulgated rules.
Could you, what page are you on, Ms. Folland?
And that is, I'm sorry, I lost that page. Let me get back over here. See, believe it was section, it's under section 35(1), and I'm sorry, Senator Scott, I did not write that, but it is.
Do you have the bill in front of you that you could tell us a page number?
I am looking for that right now. Okay, so under page 14, and it's right towards the delivery, so line 22, I believe is where that so from line 13 to line 22, and then to line 4 on page 15, where it talks about eligible and appropriate providers. The Department of Health's rules specifically state that you have to be a certified provider to receive state funds. And that comes from the certification on their website from the Department Behavioral Health Division, Mental Health Substance Abuse section.
Okay, but
So those are
Ms. Folland, that's a current rule, right? Not specific to this bill?
I believe the way I've read this, that still would apply, is my understanding from the Department of Health. And perhaps the director would be able to qualify that and clarify that.
I mean, that wouldn't be different with this bill.
It would make this, it would open this up further, because it would include the behavioral health services and the substance abuse services both, is how I.
Oh, I see. So what you're saying is that to be a recipient of behavioral health services, you need to be certified by this. So you're not getting paid by the state now then?
No, we do not.
Okay. So I do have a question about just from your clinical side. And so I feel like there are two issues here. One is what we're trying to do, which is prioritize the state funding in a time of budget cuts. The other one is the specifics as far as behavioral health centers or providers. I mean, those are really separate issues. But so as far as the prioritization of the priority populations, given that as I've cautioned the committee, I think if we don't go through with some of this, we're likely to have the Appropriations Committee decide who's the priority. So the prioritization on page 15 starts off with justice-involved people, families at high risk, people in acute mental illness who are, potential for justice involved is tier 1, then indigent high needs as tier 2, and then 3, indigent general access. Do you have any input on the prioritization?
Madam Chair, Mr. Co-Chair, obviously as a mental health provider, I would like to be able to provide services for everyone. We know that that's not possible. Even those of us in private practice right now have had to limit the people that we see because of the reimbursements that the cuts by the federal government, which then will, of course, will trickle down to the state as well. I'd like the committee to just recognize that, yes, the prioritization does need to occur. I just don't want to see us cut our nose to spite our face. And especially when I'm working with families that are transitioning between DFS and the criminal justice system. I have people right now that and I'll just put it out there. I wrote off several thousands of dollars this year in pro bono work because there is no funding for a single or divorced father who's in the criminal justice system. The family is within the DFS system and he doesn't qualify for Medicaid. So DOC doesn't pay me, DFS doesn't pay me. So, and that's just one example. And this gentleman has not only mental health, as was pointed out earlier by Representative Klim and others, he has co-occurring disorders. He has significant mental health issues, and he also has significant substance abuse issues. So I've treated him for almost a year, and when he lost his job and lost his insurance, I lost my payment source.
So it does sound, though, that with the certification challenge that even if this bill were in, I mean, it sounds to me like if this bill were in place and if your county, if the behavioral health center is not able to provide services to this person, or it would be better to contract with you, they still wouldn't contract with you because you haven't fulfilled the certification process. So, I mean, there's a number of issues going on there, which is good that you brought us up. And I'm going to kind of just confirm, are there any more questions for Ms. Foland, just so that we can, this is not the last item on our agenda. Okay, thank you very much. You've brought many useful things forward. Let's hear from Mr. Craig.
Thank you, Madam Chair, members of the committee.
Welcome to our wonderful home.
My name is Frank Craig. I'm the current president for Wyoming Association of Addictions Professionals. I also work for the Gateway Foundation that contracts substance use disorder services to the Department of Corrections. I hold an independent license in Texas for chemical dependency counselor, which I will add, I achieved that with one of those lowly bachelor degrees. I've been practicing addiction since 1994. Appreciate the opportunity to make some comments on this draft bill. I did provide a handout that specifically spoke to one of the issues that's already been discussed, and that is how to define substance abuse disorders. That would be on page 6, lines 9 through 14 in the draft. And I would add that the National Institute on Drug Abuse defines substance use addiction as a chronic relapsing disorder characterized by compulsive drug seeking, continued use despite harmful consequences and long-lasting changes in the brain. And I'll add this to the question of co-occurring because this definition includes that it is considered both a complex brain disorder and a mental illness. I think this is important to understand that when we're talking about substance use disorder, in particular with co-occurring symptoms of mental health, that you can't really distinguish between the two. And I see that throughout the bill, that there seems to be an attempt to separate substance use disorders from mental illnesses. I think that's kind of a mistake. You know, we spend a lot of effort getting recognition for substance use disorders as a valid mental health issue when the Parity Act of 2008 passed for mental health and substance use disorders. It recognized that. I do think it could be a liability for the state to mischaracterize that definition. Additionally, when there's been some questions on defining the 6-month period when we're talking about the different priority individuals, and I'll bring that back into the substance use disorder realm, because as a disease that's characterized by potential relapse, you know, it could be an individual who has maintained sobriety and maybe 2 or 3 years later has a susceptible relapse episode. And if that 6-month limitation could exclude somebody who has been, you know, on the wagon, so to speak, and has fallen off now, and maybe they just need a few, you know, outpatient counseling services to get back on track again. I don't want those individuals to be missed because of a 6-month time frame for criminal justice involved. You know, the main point of that too is also understanding that one thing that we lack in Wyoming is a seamless transition for individuals that's leaving an institution after receiving treatment, and their ability to connect, very quickly connect to a community provider to begin and continue their aftercare treatment. You know, sometimes I've seen where it's been weeks or maybe even months before an individual that's paroled out is even able to go in for their first appointment. So I'm glad to see, I think that part of the intent of this bill is to kind of address that issue, that open access issue for these priority populations, and I appreciate that part of it. And then just briefly would touch on something that popped out to me on the bottom of page 19, starting in line 20 and continues over to page 20, lines 1 through 6, and this deals with assessments. You know, many of the individuals coming out of the institutions have already been assessed. Sometimes they've been assessed 2 or 3 times. I think it would be we'd be cautious in how we define that need. And sometimes that's a barrier, in fact, for people accessing the treatment, because a particular community provider may, by their own policy, require that an individual receive a new assessment before they would even consider treating them. You know, if they've already had one, there's really no need to have another one. And people that are versed in the addictions profession would understand that the ASAM actually drives recommendations for that. A new assessment in particular for somebody coming out of the criminal justice system whose symptoms have been in remission, but it's been because they've been involved in the criminal justice system. Not many things have changed in their life history that a new ASI is going to fix, as far as getting a clear picture of their needs. And that's important, as that barrier could be simply the person's not able to access the treatment for that reason. And then the billing piece of that, you know, sometimes those could be upwards to $400 for an individual to get a new assessment. And they just don't have the money to do that. These people are hitting the streets, and they sometimes don't have jobs, and they have other priorities and parole fees. And then to hit them with a, you know, $400 fee for a new assessment just to get access to treatment when it's not necessary is a really big barrier. I appreciate the comments on private practice. That is a concern, although I do understand the limitations for budgetary purposes. And with that, I would stand for any questions.
Okay. I will say, Mr. Craig, just share your comments on the bottom of 19 and the top of 20. I think that paragraph is only in there because we're changing the language from sliding fee scale to payment policies. But I do think your testimony is worth, I see that Mr. Johansson from the health department is still here. Just, you know, the discussion as they develop the payment policies, your input on that is good, but I don't think there's any intention other than changing in the vocabulary right now on that paragraph. Questions for Mr. Craig? Okay, thanks very much.
Thank you, Madam Chair. Thank you, committee.
All right. I'm going to leave Andy to the end just because I know she was very involved in the drafting. Mr. Birkeland.
Madam Chairwoman, I'm Bruce Birkeland. I am staff person for the Wyoming Youth Service Association.
Great.
Which is our agencies do crisis shelters and group homes, residential treatment, and we have a PRTF. Many of our programs also do other early intervention programs with young people and their families, such as court diversion or day treatment or mentoring programs. Our concern is that presently a number of the kids in our crisis shelters, most of the kids in the crisis shelters and those other early prevention programs are not there. They're not court involved presently or at that time, and nor are they in DFS care. So these are kids that are there primarily referred by self-referral and family issues and frequently by schools. So our work is trying to keep them from becoming high-risk families. And so we frequently are working with counseling centers for the kids and families for individual and family therapy. And many of the families are not on Medicaid. At the same time, they don't have insurance or other sources of payment. And so our concern is that if these, they play an important part in helping these kids and families from becoming high risk and needing more high levels of care and more costly levels of care. And with that, I would stand for question.
So, Mr. Birkeland, having reviewed the bill, do you have any specific suggestions? So I'm looking at page 7, where we have kind of our families at high risk language. I mean, what would be, I'm not saying that we'll do this, but
right.
What would be your hypothesis? Say that do you have the bill in front of you?
I do not, Madam Chairman, but I know what you're talking of. I know the piece.
So if right now, for example, paragraph A says, children who have been discharged from an acute psychiatric facility or a psychiatric residential treatment facility and so on. Are you getting at something along the lines of children who have been discharged from or are at risk for placement to an acute? I'm just trying to, I don't want to say I don't want to do the cheapest thing possible, but what we're aiming at here. I mean, is there some sort of measurements that if we said who have been discharged from, or, I mean, because obviously not every child is even at risk of being in a residential treatment facility. But, we're trying to, as I said before, if we prioritize everybody, then there isn't any priority. So that I understand what you're saying, and obviously the prevention of having people fall into, you heard us probably, if you've been on with us for a long while, you heard our concern about the acute mental illness issue, that you don't want people to have to get into trouble before they can get help. I think you're trying to address the same issue. Any thoughts about specifics, how to most tightly define that?
Madam Chairperson, the thoughts I've had, and I'm not sure if that would be A or B are in definitions of excuse me, of defining the high risk or at risk, if that could be broadened somewhat in terms of risk, or also in terms of the other place would be in terms of the level of the poverty level, the indigent level, and those are kind of the two factors. Certainly there are kids that aren't in families that are involved and they will have insurance or have ability to pay, but the trouble is those that are at risk, maybe not high risk yet, and do not have the ability to pay. So it's the combination of at risk of becoming high risk and not having the income or meeting that poverty level.
Right. Okay, questions for Mr. Berkland? I see none. Mr. Berkland, I certainly take your point. I think it's a very valid point. We may not get that worked into the language today, but
Madam Chairperson, I'd be happy to be available in the future to help.
yeah, I'm sure there will continue to be work on this as we go forward. Thank you very much.
Great. Thank you.
Josh Hennis, still with us. Probably his family wants him to eat dinner somewhere. Has he left?
Thank you, Madam Chairman.
Oh, there you are.
I actually don't have comment on this bill. My interest was in the next item on your agenda, so not sure why I was pulled in a little early, so I can just be quiet and you guys can move on.
Very good. I thought you're listed under the joint sub legislation. Fine. Well, fine then. Okay, then Andy Somerville.
Thank you, Madam Chairman. Andy Somerville, representing WAMSAC and all your community mental health centers. I just wanted to start off by saying thank you for the wonderful discussion. You guys have already talked about a lot of the points that I wanted to touch on. And so just as a FYI, there should be an email that you guys got yesterday from me that pulls out some specific items that we wanted to comment on, and I can walk through those fairly quickly, hopefully realizing the hour is late and everybody is hungry. So, and also I want to thank Representative Larson and the subcommittee for this work. I can't underscore how substantial this piece of legislation is. It's difficult decisions and a difficult discussion because as mental health centers, we want to provide the strongest mental health and substance use network that we can. But we also have to be realistic about the state budget challenges. So the first one I wanted to touch on is just the conversation around the inclusion of co-occurring disorders. So this would be page 3, lines 1 through 3 in that Title 25 language. In the discussion with the providers, they thought it was important to include that co-occurring condition possibility under that mental illness definition. Given the discussion that's occurred, I'm going to take that back to them again and have another discussion based on the kind of the feedback that we got here from Representative Larson and Mr. Johansson. But in general, we do think it's important to recognize that, especially on the substance use side, most of the time there is a co-occurring disorder with mental health and substance use. And we've really tried to knock down those silos between the two. And so we'll leave that there. I would also just mention, for those of you that might not be aware, there's a pretty substantial Title 25 rewrite bill. And we had this definition discussion with that working group as well. It's not in the rewrite bill right now. It may be, but we want to work to make sure all of that stuff works together and lines up and is congruent as possible before we get to session if we end up with both of those bills at session. Did anybody have any questions for me on the co-occurring definition?
I guess not. Everybody's worn out.
Yep, they are. On page 6, lines 16 through 23, that's the adults with acute mental illness definition. As we read that strictly, we feel that it restricts access or in that tier 1 to people that have been involved in the Title 25 process. I don't know if that was clearly the intent of the bill. I know we've had some discussion on that already. But one of the most important things that we do in the community is diversion services. And some of our centers have as high as an 80–90% diversion rate for people that are called in for an assessment that had law enforcement contact or had a mental health crisis that triggered that. And we're able to keep those people in the community and out of the Title 25 system. And so we want to highlight that. And again, you wrap that with the gatekeeper as a really critical function. So we're hopeful that we can get some additional language in that definition to include those that are experiencing that mental health crisis. I also think the discussion was good about potentially expanding it to a year or 2 years for people that have been involved in the institution. There's a lot of work that goes when somebody comes out of the state hospital. That's not they come out and boom, they're all better. That's a lot of times a continual process to keep them stable and in the community and hopefully, moving towards job and independent housing and all of those things. So we'd like to have some additional discussion on that. I don't have a recommendation for you on that particular item as far as the time length right now, but I think we could get there easily before session. On page 8, or I'm sorry, let me back up. Page 7, lines 2 through 7 is the behavioral health center definition that we've discussed. When we read this and went through it, we felt comfortable with that type of wording. We didn't take it to mean it was excluding a center that only provided mental health or substance abuse services. Just for the committee's information, we've got a center in Teton County that provides mental health services, and then a second center that's a separate organization that does substance use. We have that also in Park County, where the residential substance use is provided by one agency and the mental health contract is with a different community mental health center. Those are the only ones that I can think of off the top of my head that function that way, but we do have a couple. So if we need to look at that a little bit more, we can, but we didn't read it that way when we went through the bill. Next item I wanted to hit was page 8, lines 9 through 13. And this goes right to the heart of that kind of priority conversation in terms of the definition of an indigent client, and specifically to that 100% of federal poverty level. Right now, I believe current statistics from 2019, we've got about on average 9.9% of Wyoming that lives under that 100%. We've got 15.8% that live in the 100 to 199% level. And so there's been a lot of discussion today about accessing that additional payer source at above 100%. What I can tell you, the reality on the ground at the centers is even if they do have an insurance plan, whether it's through the exchange or they happen to get a really great low cost insurance plan through their employer, a lot of times, even with $1,000 deductible, this is out of reach for them. They can't afford the co-insurance or the copay, or certainly not like a $1,500 deductible. And when I looked on the federal exchange this week, I think the lowest plan I saw was $1,500. Don't quote me on that for a deductible. But we want to check some more into that because we're not sure realistically that there is another payer source to access. As of this moment, we can talk about things like Medicaid waivers, like a community home services waiver or an 1115, but we think that's kind of further down the line in these discussions in terms of where we can pull more payer sources in. But we don't believe that there's just a pool of people that are eligible for insurance that could potentially fund those services. So we're making sure we're still reaching those people for services.
Chairman Scott.
Yes, Madam Chairman, on that issue of the deductible, it has been that the deductible didn't apply to people in the 100% plus to, I think it was, I don't know, it was 200, 250% of federal poverty because of the federal rules. So that was irrelevant to this near indigent population we're talking about. Has that changed in some way, or is that still the case?
Ms. Somerville.
Madam Chairwoman, Mr. Co-Chair, Chairman Scott, I cannot actually answer that question with any accuracy. I'd be happy to look into it, or Mr. Johansson might be able to give me an assist here. He might know off the top of his head, but if not, I can certainly check into that and get back to you because I think it's germane to the conversation, certainly.
I can say I was assisting a constituent who it was a family of 4 with an income of about $30,000, which is, I don't know at what poverty level, 150% or something like that, maybe. And if you put the Obamacare, if you can pick all these options, and if you put so that they would have no monthly payment, they did have a deductible of, I don't know, like $3,000 or something. The only way so I think that they still have deductibles, Chairman Scott, at a pretty low income level.
Madam Chairman, I've heard the opposite. I think the agency, we get this to session, I think the agency we need to talk to on this issue is the state insurance department. Because this tends to fall into their jurisdiction, and the health department really hasn't had much to do with it. So I think that's a question of fact we need to explore with the state insurance department.
Okay, Ms. Somerville, did you have something else to present?
Madam Chairwoman, unfortunately, yes, and I apologize. So just on that topic, we'll do some more research on that, but it's likely we'll come to session and we may want to talk to, bumping that up to 150 or somewhere in that neighborhood, depending on what information we get back, but we'll have that conversation before session. Starting with, I guess, just in general, all of these 6-month qualifiers, I appreciate the conversation today, just clarifying that that's not meant to be only 6 months worth of treatment. Because we were reading that 2 different ways and we wanted to make sure that was pretty clear. We do want to have before session some sit-down conversations with DOC and the House Bill 31 working group to talk about whether, as was described by a few other people, if they have a relapse and they're still on DOC parole, if there's sanctions, those types of things that we were really trying to, with the work on House Bill 31, that working group, we were trying to drive towards making sure that we knocked down as many of those barriers as we could to really help with the recidivism rate. We want to have that conversation with them, and hopefully we can come back with some recommendations on whether 6 months is okay or it needs to be longer.
Okay.
Madam Chairwoman,
Mark?
Mr. Co-Chair has a question.
Oh, Chairman Scott.
Yes, Madam Chairman, if when you talk to your people about the 6 months, I think we're all clear that, and I think the language is fairly clear, that it is not the treatment time, it's an eligibility issue. And I hope you'll explore a bit, is it appropriate to use the same 6 months all across the eligibility, or in some of the cases, as we try to deal with relapses and whatnot, is a longer period than 6 months appropriate?
Senator Bouchard.
Thank you, Madam Chair. I have a question. There was a working group, and Ms. Somerville, I guess you were part of that working group?
Madam Co-Chair, Senator Bouchard, yes, WAMSAC is a member of the working group for House Bill 31.
Madam Chair, I'd like to know how many people were part of the working group that were not part of your association.
Ms. Somerville.
Madam Co-Chairman, Senator Bouchard, I can't speak to how many people were involved in the conversations as the bill was going forward and passing. We came on board to what I would call a working group. Apologize if I'm mischaracterizing that, to specifically talk about that transition from DOC facilities into community mental health centers. If that parolee requires care, making sure they get it quickly, doing the warm handoffs. So that was our part of it. And we've had those conversations specifically with DOC and DOH as part of the House Bill 31 implementation process.
If you could, Mr. Johansson, are you here?
Madam Chairman, yes, I am. Sorry.
I was just wondering if you could help out Senator Bouchard there. As far as the working group that you folks are having with Department of Corrections on following on House Bill 31, what is the breadth of mental health and substance abuse providers that you have involved in that?
Madam Chairman, let me get back to the committee on that. I'll have to touch base with our behavioral health division. I know I just haven't had a status update in a little while on how that working group or groups have grown and what's been going on recently.
Okay, we'll appreciate some feedback on that. Okay, any more questions for Ms. Somerville?
Madam Chair, I just have a few other quick items to touch on.
I thought you were done.
Apologize. On page 9, lines 9 through 10, we would recommend removing in that definition B. Right now it says that they've been convicted or pled no contest to a criminal offense in order to enroll in an intensive outpatient treatment program. We would recommend that you remove that intensive outpatient treatment program and just insert treatment for mental illness. That's just a practicality if the names change over the years or if it's a slightly different type of programming or services that they need. I think the committee's intent or the bill intent was clear to me, but I think that would be something we'd want to consider removing.
So you're saying that's sort of a specific term to the to programs that might change?
Madam Chairwoman, yes.
Okay.
And then probably the biggest thing that I wanted to discuss with the committee is page 15. This has to deal with the tier system. It's something that we've had you guys have had a lot of discussion on already. The first part of the discussion is under adults with acute mental illness. Just again, reemphasizing we want to work on that definition to make sure that people that have not been in the state hospital or something can receive those diversion or gatekeeping services potentially. And then the biggest item is when we met previously with the subcommittee, we've discussed general access for assessments as something that the Community Mental Health Center see is pretty important because we can't quite figure out how we prioritize or find out where somebody fits in the tier system until they've actually walked in the door. And I want to characterize that by saying even with the current state contract right now, the state's the payer of last resort. So if somebody walks in the door with private insurance, then the center's going to bill their private insurance or Medicaid, not the state contract. What we're concerned about is as we reduce that indigent population, potentially right now it's 100%. I think it's still a really important function to be able to get those people in the door, have an assessment, figure out if they fit on the tier system. And if they don't, the Community Mental Health Center can refer those out to private providers if that center doesn't have the resources to see those people or try to figure out some other way to get them into services. But that first assessment and that first appointment is pretty critical. I know that I can't tell you how many people that would be right now, but we do think it's an important piece to consider adding back into the system.
So with that regard, would you consider, so on page 15, I'm looking at picking up in the end of line 16 and 17 with the essential subsidy payments in addition to other contractual payments, would you not feel that the assessments of indigent people in general could fall under that, or are you thinking that it needs to be specifically identified?
Madam Chairwoman, I think the subsidy payments could be a perfectly fine avenue for that type of service, but there was some discussion with my providers if the subsidy payments were intended to just support operating expenses, or they're really supposed to help, especially the rural or smaller centers, support that general access where there's nobody else to get it. So it's a question of, is it operation expenses or direct services? And I think that's a conversation we'll continue to have, and certainly would flesh out more with the Department of Health if this bill were to pass. Those are my immediate thoughts.
Representative Larson, do you have any thoughts on that discussion?
Madam Chairman, we have had some discussions on there, and I think I think what we're trying to do there, I think the association has a valid point, particularly if they're coming in from corrections or coming back out of the a Title 25 placement. You would think that some of those screenings would already be in place, but yet some may not. And to determine where they fit, I think is a reasonable approach, yet making sure, kind of like we've had on the rest of the discussions, we have to approach it with some caution and some checks and balances, because the intent is not to use the general funds for general access assessments. And so I think the discussion is worthy of further of having and seeing if we can't work out, because I think she has a valid point.
Just as far as providing direction to the Department of Health for rulemaking, would you visualize on line 22 where it says to help defer continuing operating costs? I mean,
No.
Are you considering the operating costs as just being rent and lights and whatnot, or are you seeing that as sort of a
Well, yes, Madam, to the latter, that this is really a focus to keep those rural running on a shoestring budget type, and they probably all are, but to those that are serving in a population where there's no other providers, to help them keep the lights on. So then in this situation, doing the assessments are going to be statewide. Every provider in the state will be making an assessment and determining what priority population they would be in. And so I think putting it in with the general access subsidy would be misplaced. I think that we need to just have that as figure out where that goes in the reimbursement, and it might come back to the discussion in section 3, but I do think that putting it in that reimbursement for general access would be a misplacement.
Okay. More questions for Ms. Somerville?
Madam Chairwoman, I'm almost done, I promise.
Oh, sorry, I thought you were done.
Just a couple of comments on the repealers that are in the bill. The first one, so page 20, 8 and 9 is where they're at. The first one, 351620. We just want to verify, and again, this is another conversation before session with Department of Health, that these statements are not required at all for our federal block grant funds. We haven't been able to do that analysis, so we just want to make sure that we're not endangering any federal block grant funding if we take those out. On 351622B, that 10% contribution match, Representative Larson was correct. I'm going to tell you that although initially it could be seen as removing a burden, I was a little surprised to hear from my senators. They think it's really important to incentivize that community commitment to the community mental health centers, whether it's from the local government or other entities, and it really helps make sure that it's a true community mental health center, that they're engaging with their stakeholders. And so they've asked me to ask you to please leave that in at the moment.
So in other words, to remove the repealer.
Yep, remove the repealer. And then on the last one, 351624, same comment. We're okay if all of those come out. We just want to make sure they're not required by our federal block grants for the state. And then on page 22, lines 20 through 22, the statement about the one of the to-do list items for Department of Health is to talk about the delivery of housing, and I think it's phrased crisis shelter services right now. One of the things that we've discussed about being in this bill is it's really hard to put residential housing into a tier system like this based on the way the state contracts for those beds right now, whether it's residential substance use, group homes, transitional housing, independent living, or crisis stabilization. And so we just asked for some additional discussion over the next year on how potentially we could either prioritize those or how that system works. And the question that I have is whether we could clarify the language a little bit, just because I'm not sure crisis shelter assistance necessarily gets to what the behavioral health centers do. So we'd recommend it's something more of along the lines of delivery of mental health and substance use disorder residential services, including but not limited to group homes, transitional living, independent housing, crisis stabilization, and residential substance use disorder programming. So that doesn't have to be exact. That's just trying to make it a little bit more specific. And that is,
I couldn't write that fast.
that's okay. It's in the handout I sent in your email. So, and then finally, the last item I want to touch on is just the timeline. For all of these items, when we're talking about potentially doing, having DOH do a new payment plan essentially to support the priority populations, that could be a really heavy lift. Before my time, but I was told by my centers the last time we talked about payment reform for community mental health centers, I think was in 15 and 16. It was a really long process and it ended up actually not going anywhere at that point in time. But my point was just to say it's a really heavy lift because there's a million ways to cut the cake, essentially. And so we want to commit to working with DOH and doing all the work. I don't know if it's reasonable to expect us to have that kind of all fleshed out by July 31st. So if the committee's intent is just to get an update at that point in time, that's probably fine. If the committee wants everything to be fleshed out, I'm not sure that we can achieve that. And I'm just speaking from the provider side. I won't speak for DOH. But we would probably need more time beyond July of that year to get that all fleshed out.
Questions for Ms. Somerville? Representative Larson. You're muted still.
I just wondered if Mr. Johansson could comment on that time frame. They'll be carrying the burden of the load. Do they feel like they can get it done in that period of time?
Madam Chairman, to Representative Larson's question, I think yes, with how the language is in the bill, I think we can update the committee. We did envision that the system would be designed and any legislative additions or changes would be proposed over the 2021 interim period. Designing a reformed system as is contemplated in this bill, yeah, it's a heavy lift. I think we have a lot of the groundwork laid from previous years, as well as work that's been going on at various committee levels over the past 2 years. So I think we can meet the timeline, but the point's well taken from Ms. Somerville with the reporting requirement out to the committee by July 31st. I think we can certainly hit that. Will the system be turned on or ready to be turned on by then? Maybe not. There could be some additional statutory changes, very similar to the facilities task force, where after the system was designed, some definitions needed to change, some additional work had to be done, but the work kept moving.
Okay, more questions for Ms. Somerville? Chairman Scott, are you raising your hand or just contemplating? All right, okay, thank you very much. I
Chairman.
think, okay, that is the last of the people. Is there anyone who crept in late for this?
Ma'am, we don't have anyone else for this particular topic.
Okay, all right, so committee, before I ask for if there's a motion on the bill, plainly we want to do some more work on this. We have a couple of things to just kind of consider as we talk about this. We do have one item left on the agenda, which, as I suggested before, and is Ms. Burke here or someone from the insurance department, Elizabeth?
Ma'am, we do have Commissioner Rude and Ms. Burke here in the waiting room.
Good. So they're probably going to chat really briefly, because I'm sure they're hungry for dinner, on item number 7. But that really will not take any time, I wouldn't say, maybe 10 minutes, just because of how I explained before. So that's not the issue. But we have a couple of options. I mean, one, of course, we could just say, no, we don't want to bother with this bill at all, and we'll just let JC do whatever they want to do, and we won't run the bill. I mean, that's an option. the other option is to move the bill. We may have a few really brief tweaks that we want to do, like, changing the 6-month thing, or, something that is relatively short that we can all hear and comprehend, such that we can then vote to move it forward to session, knowing that then there will probably be more amendments in session, but that will be more substantive and probably need more time from us. Another option is we have posted notice that tomorrow is continued consideration of legislation if necessary. So the other option would be, if there are just things that you just really need to get off your chest on this bill tonight that are longer, we could move the bill just so that we've said that we're doing it, and then come back in the morning and work it longer. I have to say that's not my favorite choice, because I'm really kind of sick of this, but sorry, I'm still coming live, aren't I? So I would be glad to take some input from the committee. Chairman Scott.
Madam Chairman, I would urge the second option. I think it's very important. I think there's some real problems in this bill. But I think it's very important that we have a priority system in the works to consider as we consider the budget problems we're going to have to. And I would much rather it be a Labor Committee bill. And we haven't introduced extraordinary number of bills or complicated bills. So we have a lot of committee time, frankly, during session that will be available to work this, that I don't think appropriations would have because of their other responsibilities. So I think it's important that we do it. Frankly, there's a number of items going to need some work here. There's a few things that if they were there on third reading, I wouldn't vote for the bill. And that includes some of the repealers. But I think it's important we take it forward. And I will say, frankly, the committee, I'm not able to do some of the amending work I would like to do because very specific to me, I had bandwidth problems and problems understanding a fair amount of the testimony because of it. Just the limitations of the Zoom system in this rural location. So apologize for that, but that's just the way it is. So I'm going to urge the second option, and I think we could probably do it pretty rapidly.
Any more comments on that? Senator Bouchard.
Thank you, Madam Chairman. I have a real problem with this bill. It's almost like let's pass something and see what's in it, and I think there's going to be a lot of bad consequences here. There isn't a magic pill. We're going to have to cut and appropriate, and I think all of us need to be part of that process. I think this kind of bypasses some of that. And I'm telling you, there's a part of heartburn that really bothers me is I had the privilege of being on a funding model committee, and there has been some things that happened in some of the centers where there was some spending that didn't help the mission. And I won't get into those details, but the funding model committee, where we had the previous director actually put together I'm loosely saying it was software, but it was data and algorithms to look at the health of the people who are getting contract money. And I just never forget that when WAMSAC testified, they said it wouldn't be good for the public to see that. And I just think that I've yet to find where that model that was built has ever been used. We're not looking at some of these things of where this money, how much money's there, and how it's being distributed over the period of a year. I mean, those were some of the things that were in that funding model software. And then lastly, as we just discussed, I mean, about the input in the working group. I mean, it almost seems to me that there's one voice that gets a lot of horsepower there, and they have directly an input on who gets, they're gonna benefit from it. So I'm having a problem here. If we have to go back to session and cut somewhere and appropriate, we're gonna have to do it. I just don't think this is the right way. So I'll leave it at that.
Okay, more comments? Senator Schuler.
Thank you, Madam Chairman. I think, I would like to, first of all, thank Representative Larson and, the select committee for their work on this bill. It's a heavy lift. There's no doubt about it. And, Representative Larson he's like the man as far as I'm concerned. He's the expert on so many of these things. He's done a great job and kind of leading us through a way to prioritize our health, our mental health folks and our substance abuse folks, and to try to prioritize our populations and to try to help us a little bit with budgeting. And that was really our biggest need, I think, with this. It's a twofold deal to provide the best care we can for our constituents, but also maybe we haven't prioritized it in the past like we needed to. Again, I can't say what's happened years ago because I'm still fairly new at this, but I just think we actually had come up with a pretty good bill. Yeah, it needs some work. I think there's actually some of the amendments that have been tossed about, or potential amendments, I think have merit, and I'm okay if we do them tonight or tomorrow. It doesn't really matter to me. I'm a late night owl, but I think it does need some work, but I think it's a bill that needs to move forward, and I'd be happy to make that motion with the idea that we are going to have to do some work on it. So that's my thought. Thank you, Madam Chair.
Representative Barlow.
Madam Chairman, this is maybe a question at your leisure for staff, is where the committee is in its budget. There are other committees, other standing committees that are requesting extra days to finish up work on bills. So I know you gave two choices, work it tonight, work it tomorrow, but actually, if we want a good legislative product, we probably all need to reflect on the comments, the public comments, and then bring forth suggestions, and maybe a meeting in 3 weeks or a month might better accommodate that. So maybe for our staff, would we have enough money for a one-day Zoom meeting if we sought and received approval from Management Council? Thank you, Madam Chairman.
Mr. Brody or Mr. Shaw?
Madam Chairman, the last time I had an update on the budget for the committee, it was in a pretty healthy position. You certainly have enough money for a meeting tomorrow. I guess unless Ian has anything to add, I'm fairly confident that you have enough money to do another day in addition to tomorrow, if necessary.
But so if we didn't, what I take from Representative Barlow is perhaps we wouldn't even meet tomorrow, but we would postpone that one day to somewhere else. If we have enough money for tomorrow, we have time to do it in December. Okay. Representative Clem.
Thank you, Madam Chairman. Yeah, I agree. I'm definitely not comfortable moving forward a bill or sponsoring it as a committee right now, simply because this is a significant lift. I think it goes without saying that this is a discussion that needs to be had. I really appreciate those who worked on it and what they're endeavoring to do. I don't feel that we've gotten the amount of public input on this bill. And I, at least speaking for myself, am not confident in knowing exactly how this bill is going to impact things in the long run. I think that's yet to be seen. And so we're going to have this discussion one way or the other, because, this is a bill, this is a vehicle to have that discussion. If we didn't have the bill, we would still have the discussion as a legislature on in our budget hearings and whatnot, and on the House and Senate floor when we talk about the budget and amendments, and it's going to be had one way or the other. So I don't think it's one of those things that we absolutely have to have. But if we are going to take this seriously, I do think that I'm more of the opinion that we have another meeting in December. If the committee is serious about sponsoring something like this, I have some reservations. This is really the kind of subject that could be dealt with throughout an interim. And so depending on even how it goes this next legislative session, it probably would be a good thing to look at as far as an interim topic, something to look forward in more depth. So that's my 2 cents. Thank you.
I will say, committee, of course, this has been the work of an interim. We had a joint subcommittee of JAC and labor, I think we had, 4 meetings, Representative Larson? Plus your thousands of hours, but it is the product of hearings and discussion. Representative Hallinan, good job putting up your blue hand.
Thank you, Madam Chairman. I think that the subcommittee has given us a good bill and that we should vote to move it on to the session. And that's where I think that would be appropriate, that these issues be developed on the floor when it gets introduced, and get developed in the committee when it gets to our committee again, to both committees, the House and the Senate committee. So there's plenty of time to discuss this bill. I think that we should approve it now and let that go until the session after that. Thank you, Madam Chairman.
Thank you. Senator Bouchard, do I see your hand again?
Yes, Madam Chairman. Most of this work was done on this bill on an inside work group. I mean, I don't feel like the committee did all this work. I think it was something else. So, I mean, yeah, I was there at the committee meetings, but I don't feel that this is the kind of product that the committee itself did.
More, Representative Sweeney.
Thank you, Madam Chairman. So I think I was listening into a little bit of appropriations a week or so ago, and I think either this committee, this is just a statement of what I recollect, but I think either we move it forward or my impression was joint appropriations would move it forward if they needed to. But I remember the comment from somebody that this was well within our wheelhouse in this committee. So I sure don't want joint appropriations. Yeah, I would rather us work at joint appropriations at this point. I would agree with you, Madam Chairman.
Any more questions on this or remarks? Representative Larson, you're waving your hand there. He wishes he were still on Labor Committee. I know it.
Well, I only want to make a comment if I'm not a member of this committee, chaired the subcommittee. I just think that there's some relevant points there that just in the process that maybe warrant some public comment on there. Madam Chairman, to your point, this has been an interim discussion. We did have 4 committee meetings, and at the end of the last committee meeting, it was noted to put some language together to bring to this committee today. Hence, that's what we done. We worked with LSO on taking the priority populations that every member of the subcommittee participated in, both on the House side and even those on the Senate side, and participated in providing information to. We took those information and took and did indeed draft this language. And then this forum today is, and we did have public comment, but this forum today then is how we look at that language and see if it's something that you want to move forward. But I to suggest that there was something that was maybe not quite up to snuff, I think might be, at least in my opinion, was not the intent, nor did it happen.
That's true. That, I mean, the joint subcommittee was set up by Management Council when the interim topics were assigned, and the subcommittee was assigned to look at this topic. So that is what we have been doing all the summer. I would just say, as far as having it be come up with on the floor, truly we will have budget discussions, but we know we've heard many times that we don't want to legislate in budget footnotes. And I would really hesitate to draft some sort of budget footnote that put a prioritization in it that would only last for 2 years and had no further sideboards or anything. I think that would be, I hate to think what what might come of that project. So we've tried to move away from that kind of procedure, and I support that move away. Okay, I think so I think the first question is, the first vote I will take is, do we want to move the bill forward? Because some people may just say, no, we don't want the bill move forward. And then if the bill is moved to go forward, then what I will ask the committee is, do you want to make a small amendments yet this evening and then vote on it and then revisit in session? Or do you want to come back at a later date? And if people vote for the later date, you see this is quite a flow chart, then I will ask, do you want to take use of our day tomorrow or actually come back again in December? So I will have sort of flow charted out that way. So the first question is, all who are in favor of sponsoring this bill from the committee in some way or other, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Okay, 11. I see there are 11 votes. All opposed? Please raise your hand. 1, 2, 3. Okay. So having it move forward, so I'm just marking this down. I called that go. So then the next question is, do you want to attempt to make small changes tonight and then leave it to session? If you vote no, then I will ask about timing. So the first question is, if you want to make small changes tonight and leave the rest to session, please raise your hand. 1, 2, 3, 4. I think I'm seeing 4. So if you want to have another meeting before session, raise your hand. 1, 2, 3, 4, 5, 6. That's not 14. Hey, some people didn't vote. I'm going to check this again. Okay, if you want to make small changes tonight and then leave the rest for session, please raise your hand. Put it up big, high. 1, 2, 3, 4, 4. Still 4. Okay, well then I guess we'll have another meeting. Okay, so then the question is, do you want to take advantage of our scheduled tomorrow meeting? And if you vote no, then we will schedule another meeting at some time that the chairman and I pick. Chairman Scott has a question. Or are you voting or are you asking a question?
Madam Chairman, no. What I'm going to urge the committee is that I don't think we can do enough work to really deal with it tomorrow. I think we need some time to reflect, to draft some amendments that can be distributed. Since we're going to have, we have the budget, especially if we don't meet tomorrow, I think we need the time to circulate things and time to think about it. And maybe even some of us who are working on amendments consult some of the experts. you know, we pushed this forward in a hurry because we think, and I confess to being one of the guilty parties. We pushed it forward in a hurry because we're going to need it to deal intelligently with the budget. Otherwise, we'd say go to next interim. But I think we do need the extra time, and I would strongly urge the committee to let's give us enough time, maybe to sometime in the first few weeks of December.
Representative Barlow, did you have a comment or question?
Madam Chairman, just to be clear, I think there's discussion within Management Council. They'll be meeting next week, I believe. So if there's a letter from the co-chairman to Management Council asking just to move to you gave up one day this week to have a meeting in early December, I think that would be received favorably, and I will certainly be supportive. But I do think you need to at least notify Management Council so that LSO can make sure they have enough resources and scheduled wise. Thank you, Madam Chairman.
When are they meeting again?
Madam Chairman, I believe that I think last I heard is there's consideration of having a Management Council meeting in the next 10 days. Next 10 business days, next 2 weeks.
Okay. Okay, so back to the votes I will take are to either meet tomorrow. Yes, I mean, if you vote yes, it'll meet tomorrow. If you vote no, Chairman Scott and I will pick a later date upon consultation with people's schedules. So how many people are in favor of meeting tomorrow for further amendment? Nobody. How many people are in favor of meeting at a later date? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 2 people didn't vote, but okay, 12. Sorry, you don't really get to abstain, but okay. So then Chairman Scott, do we need to actually, well, we'll just carry this forward. Is that the correct procedure? Okay, LSO, do you have questions on this?
No, ma'am.
So what we will do is, Chairman, and I'm not adjourning yet, so don't everybody go away. We have one last topic. Chairman Scott and I will consult on dates, and LSO, we will certainly consult with you because I know as we get into December, some of you may have other responsibilities. And then we will post this bill again. We will not, we're not going to be open for public comment on the next one. It will really be consideration of the bill, although I think we will probably ask the usual suspects and people, you know, we may call upon people, but we're not going to just take open public comment on, I'm not sure about that. Chairman Scott.
Madam Chairman, after we've consulted with the LSO tomorrow on this, I think committee members will probably ask the LSO to poll you on a range of possible dates, probably first part of December, first couple of weeks in December, to see if we can get a date that most people can make.
Right.
So ask people to respond.
Right.
They
I'll
get
probably
that
send
call,
out,
respond
I'll send out a
promptly, so
Google
be
poll or
prepared for it.
something like that. And also, folks, if you have amendments that are longer than like 3 words, it would be really helpful if you type them up and send them to LSO for distribution, because it's just very difficult if you try to articulate some sort of paragraph long amendment. It's just really too hard to consider. So I would ask you folks to start, you know, if you've got things that you want to put in, actually type that up. Okay, so this particular bill will be put off to we've agreed that we will sponsor it. I mean, I guess we could decide to change our mind after that, but we are going to move it forward to a future meeting. We will not meet tomorrow. And then with that said, we are going to go on to the last item. I guess there is general public comment at the very end. I have not forgotten that either. Consideration of draft legislation LSO 240 State Health Reinsurance Program, which, as I said, I'm pretty sure we're not going to actually do anything with, but I left the bill on there just for our discussion. And if we could wake up Mr. Rude and Ms. Burke and let them in. Those of you who've been on the, well, actually, I guess all of us, this is really a sort of a remise of the bill that we had 2 years ago. And I am on the governor's healthcare task force, which is one of our tasks is to look at the high cost of healthcare and ways to bring that down. And it was brought up that some other states are, after several years ago when we considered it, more states have passed these sort of risk pools, and we thought, well, maybe it's an option. However, at this point, I don't think it's currently an option, but we will hear from, it looks like Ms. Burke, and just to kind of give us an update on where we're at with the concept and what the concept is as a refresher. Ms. Burke, welcome. Sorry you've had to wait, for the year and a half. But
thank you, Chairman Wilson and members of the committee. I'm actually going to, Commissioner Rude is on the line as well, and he is going to be actually providing the briefing, and I will answer specific questions as they come to me. But
very good.
Commissioner Rude is actually going to do the briefing.
Commissioner Rude, I see your black rectangle. Carry on.
Yes, Madam Chair, I apologize. We had internet issues throughout the day at our office, and so we just scurried back to our homes and are doing what we can. Very briefly, just because I know the hour is late. The basic overview of a 1332 waiver, and I'll tell you, what we'd previously done, I'll touch on that. So under the Affordable Care Act, a state has the ability to apply for a waiver to change certain provisions, but there's some guidelines. The coverage provided has to be just as comprehensive. You have to cover the same number of people, and you cannot increase the federal deficit. So those are the guidelines that you must meet. Generally, the process is you would conduct a study, you would prove to them that you actually have met these requirements, and then the state actually must pass legislation before the application would be considered. They didn't want states, some political fighting at the, between the governor's office and the legislature at the last minute to derail an application after they've approved it. And then you have to do an actuarial study as part of the proposal and submit the application to CMS. It's actually quite a long process. There's a state hearing involved. There's a state comment period. CMS has 45 days to ensure the application is complete. There's a federal comment period. And then finally, CMS has 180 days to decide whether to approve it or not. So what we'd done previously, we were considering a 1332 waiver specifically to create a state health reinsurance program. And briefly, a reinsurance program is where you take the high expense healthcare claims over a set amount. For example, above 200,000 or 250,000 per year. And then that would be covered by the reinsurance program, the state reinsurance program. That reduces the cost to the insurance company. That results in their having lower premiums, which then results in a lowering of the subsidies the federal government has to pay. And those reduced costs to the federal government can be passed back to the state and used to fund and pay for the reinsurance program. So that's really just how, the guidelines. Previously, the legislature appropriated $200,000 for the department to conduct a study on the feasibility of a reinsurance program. The goal was for us to use any saved pass-through money plus a 1% assessment on health insurers to pay for the reinsurance program. We were initially shooting for a 20% reduction in insurance premiums. We went ahead and we hired a company to conduct the study. The initial study came back and it looked as though with the proposed assessment and the pass-through federal money, our reinsurance program would reduce the premiums around 15%. So we didn't quite meet the goal, but 15% wasn't bad either. Where the legislation ran into some problems was ultimately some of the insurers wanted to be exempt from the assessment. They didn't want to, since they felt that they shouldn't be assessed since were not selling comprehensive medical insurance. Some of these companies were selling hospital-only coverage or, disease-only, like a cancer-only policy. And so once a change was made and you took those companies out of the assessment pool, there's fewer dollars in the program, and then that 15% reduction would certainly go down significantly. You could always assess more of the remaining people, but the bill actually capped assessments at 1%. So once these changes were made, ultimately the bill did not pass. If the committee wanted us to look at this and take a relook at the waiver, I think we would first need to talk with the contractor and who conducted the study and just sort of get a guess from them what they think the cost would be to update the study. The previous study has claims data from 2017 and earlier. We would need to update it with 2018 data and 2019 data. We would have to come up with the funding for that. We would also have to get an estimate of what an actuarial analysis would cost. And then we'd come back to see if the legislature wanted to pass the legislation to submit the application. The only other two things I'll point out that we need to keep in the back of our minds. We have a new insurer on the marketplace. Their claims data will not be known for at least a year. And they don't have a claims history here. Now, obviously with our previous insurer, we have a very good claims history and we know what to expect there with those figures. If there's a new insurer though, that could be a little bit, they could do better, they could do worse, but that might ultimately affect the pass-through money that the state would receive. So that's just out there for consideration. And then lastly, the other factor is the pending Supreme Court case. That's going to be argued 10 November. And then we'll get a ruling on whether they will uphold the ACA or not, probably 6 months down the line, maybe 8 months down the line. And we'll just have to wait and see how that affects things. So I kept it kind of brief. I'm happy to answer questions if you have them.
Thank you, Commissioner. Do you have a few examples that are since the 2019 bill as far as the kind of savings that states have experienced through their 1332 waivers?
Madam Chair, it's difficult to compare because we're one of the few states that was not putting skin in the game from the general fund. We were only doing assessments and then we were looking for the pass-through savings. Maryland, for example, put in, I want to say close to $100 million. Other states put in $50 million. And so they put in additional funds. They got a bigger bang for their buck. Some of them were significant though. But once again, they put more money, they had more money to play with. And so it's difficult to compare. Ms. Burke might have more specifics, but that's the real variable in all of this is you've got to have money in to get the money out. And they brought it in from the general fund, which we knew we weren't going to be able to do.
It's sort of like an upper payment limit program for insurance, isn't it?
Exactly. And that helps the insurance, the insurer likes that because they don't have that unknown variable out there of a very high, expensive individual might have $500,000 in claims, but they don't have to worry about that.
Chairman Scott.
Yeah, Madam Chairman, I had the role of trying to sell this to the Senate and didn't succeed. That's where it was defeated. And my sense is that the primary problem in the Senate was not so much who got the assessments, but they thought overall we were not getting enough bang for our buck in terms of whether you did it with an assessment or any other way. We weren't reducing the cost to Wyoming individuals enough to justify what we were going to have to put out, and we were primarily subsidizing the federal government. That's, I think at this point, I'm not sure I could convince the Senate if I wanted to feel any differently than what they did.
Okay, let's hear from Ms. Burke. Do you have anything that you want to say, or are you just here to answer questions?
Thank you. I basically was here to answer any questions, but I didn't have anything specific to add, but I'm happy to field questions from the committee.
Okay. Representative Sweeney.
Thank you, Madam Chairman. Did we look at something similar to this maybe 4 years ago when it came to organ transplant? I'm trying to remember if it was kidneys or something or was that the state pool?
We did change the state's, forget what we call it, but the high risk insurance plan that the state has for uninsurable people that covers like the Medicare. It's kind of late in the date, but that was specific to organ transplants. That wasn't, we weren't trying, that wasn't a high risk pool that we were setting up. That was a change of a benefit to an existing program. More questions for the insurance department? Okay, as you see, committee, I did bring this forward because we had an interest for a little bit, and then I looked into it more, and it does sound like the whole the lift of needing an appropriation to do more actuarial studies and go on is just probably more than we're really up for at this time or even in the next year. But Chairman Scott.
Madam Chairman, with the insurance department here, because they're involved in this one, we're starting to discover a problem in the Medicare supplement area. The deal has always been that if you signed up promptly, you wouldn't be medically underwritten and wouldn't have to face medical underwriting in the future. The feds abolished one of the very popular supplement plans, and you didn't have to transfer out, you could keep it, but the premiums are starting to rise and the companies are starting to medically underwrite. It looks like a problem that's going to grow. I just wanted to alert the committee that you may hear some complaints as medical underwriting starts to occur in this, and there may be some things we can do about it, either petitioning CMS on having a special enrollment the way Colorado did, or flatly forbidding the medical underwriting. We're very early into this, but I would ask the committee to be aware of it. And if you start hearing major complaints, call me or call the insurance department so that we're aware of what's going on.
Commissioner Ruud, do you have any other information about this issue?
Madam Chair, Co-Chairman Scott, we have been in contact with Colorado, and that's what I believe Senator Scott's referring to, that they passed legislation on this, but they're just rolling it out, and we're getting the feedback from them on how it's working and whatnot. So we'll certainly be happy to provide any information we're able to get with the committee and work with Co-Chairman Scott if he wants to, come up with something. But we're sort of new to this too. It's in the early stages, and we're just trying to figure it out ourselves.
Okay, I have one other question while we have the Department of Insurance here. Maybe a day and a half ago in this meeting, or at least several hours ago, there was a discussion about people buying insurance on the exchange, and we were discussing whether to put 100% of the federal poverty level as a bar for a certain program, with the idea being that over 100% of the federal poverty level people can purchase through the exchange. We had some discussion about whether there is still typically a deductible. Let's suppose that a person, a family at 125% of the federal poverty level or so, if they attempted to buy a plan with no monthly premium, is there a premium? Or in other words, is it possible for a low-income family to buy on the exchange and have essentially a free plan with no premium and no deductible, or do they have deductibles? Some of us have sort of fiddled around with it, but can you give us an answer on that?
Madam Chair, I think when Co-Chairman Scott raised that about 18 hours ago, that question, we had someone in our staff try to pull up some of the data and some of the plans themselves. We first saw some plans and there was some deductibles, but didn't have the time to pull into different levels of the federal poverty level. So what we'll do is we'll pull that up, we'll send it out to you tomorrow, and we'll give you the examples. We did see some with deductibles, but we couldn't do a range of incomes just because of the time, and having the committee up on one screen and trying to find it on healthcare.gov was somewhat difficult. So
right, I think the simplest thing, because we don't need a whole Excel file of it, but if you just set up a hypothetical family of 4 and then find out whatever the 100% federal poverty level is and put $5,000 extra on it or something, so you've got, say, a family at 120% of the federal poverty level and maybe 200%, just to give us 2 things, but then set the deductible at 0 and see what's the lowest monthly premium. And of course, then there will be, just put a note about there may be copays, and then set the monthly premium at 0 and see what the deductible is. Just give us like a 4-box matrix. We don't need to know everything, but that'll at least, Chairman Scott, do you think that would be a sufficiency?
Yes, Madam Chairman. I think a brief with an example with 3 or 4 relevant levels of federal poverty and what the deductible, if there is one, would be, because I think in some cases there may be not the full 1,000 or 1,500 we hear about, but much more nominal deductibles too.
Right, just some basics there would be good. Okay, is there any final questions for Department of Insurance? Please say no. Okay, committee, then, is public comment. Golly, I nearly forgot. Is there anybody slightly deceased person out there who's been waiting to make public comment? LSO, anybody there? Oh, it's Josh.
Josh.
Josh, welcome back. He's turned into a bison.
Thank you.
Oh no, there he is. Okay.
No, I'm back. Thank you very much, Madam Chairman, members of the committee. Once again, Josh Hannes with the Wyoming Hospital Association. Again, because it's late, I will be brief, but I certainly appreciate what the insurance commissioner brought up and Denise brought up with the challenges of moving forward with a 1332 waiver at this time, and it is a big lift. I agree. I think the one request I would make of the committee, because this is an idea that we believe has some merit and has the ability to at least in part lower some healthcare costs for consumers, that if there's any way we could move forward to at least update the estimates to see what it might take from a state perspective, what would need to be contributed from an assessment point of view, and then what the resulting decreases in insurance premiums might be and what the federal pass-through could be. And if there's a way to move forward, at least in that space, so we're working with knowns and can make an educated decision on how to move forward, I think that would be very helpful. And just if I could for one moment go back to Chairman Wilson's question. And again, I completely agree with the insurance commissioner about not being able to compare apples to apples. It looks like Alaska, who I think was one of the first states to do this, they receive about $60 million in pass-through money. And I think, and they seem to be the lowest in terms of how much they contributed. So they contributed about 3% of that. And they saw 20% reductions in their insurance premiums on the market. So like I said, if we could at least get some updated estimates and work with good information, I think that would be a good step forward. And I'll stand for questions.
Questions for Mr. Hannes? So I would say, Mr. Hannes, maybe at the end of session, whenever the end of session ends out being, you could come back on our interim topic day and kind of remind us. We might at least put it on the interim topic list again for consideration. We might hear from the Department of Insurance what their discussion with the contractor has been. you know, it certainly we're cutting left and right, but if we can perhaps through the assistance of the governor's healthcare task force or something, pry loose, you know, $30,000 for an update or something to make a reduction of 15 to 20% in people's insurance premiums, you know, it might make, who knows what next summer will bring. But anyway, I would suggest bring that in when you come in at the end of session. Representative Sweeney.
Thank you, Madam Chairman. So maybe to Josh and Denise, so with the layoffs in the energy sector, have you heard of any complaints about COBRA? You know, that they can't, if they were forced to take COBRA with their furlough or layoff, and not be able to get to the marketplace, which I think is relevant in this discussion. Is the insurance commission or the hospitals actually had any complaints that way? You know, how do we get there? You know, while we're laid off, unemployed, and really not receiving any benefits, but because of the laws the way they are on COBRA, have you received anything on that?
Commissioner?
Madam Chair, Representative Sweeney, Ms. Burke did some yeoman's work with regards to CMS and working out a special enrollment period for some of the minors initially when they were laid off. And that was a rarity and a real coup for us in the sense that they were able to sign up months ago when the layoffs occurred instead of having to wait for you know, open enrollment, which is occurring now. We've worked with them. We put information out. I don't know how many complaints we've actually had. I'll defer that to Ms. Burke, but I know we've done quite a bit of outreach with their options in that area.
Ms. Burke, any follow-up on that?
Yes, thank you, Chairman Wilson, Representative Sweeney. We did get the special enrollment period, as Commissioner Rood said, and most recently, we did get some CARES Act money that from the governor's office that is then going to enroll Wyoming with particular focus on those individuals who were laid off because they didn't have access to information about insurance, about how to get to the marketplace and so forth. I have not heard of complaints beyond that, but the CARES Act money is being used to help them find their way to the marketplace. And we hope that that will be at least one thing that could help them find their path through this. It's difficult. There is no doubt about that.
Thank you.
Okay, thank you. All right, committee. So tomorrow or the beginning of next week, keep an eye out for a doodle poll or some such in your box if as far as a December meeting. John Brody, Mr. Brody, are you still here?
Madam Chairman, yes.
Can Co-Chairman Scott and I have you draft a letter for us to send to Management Council, just requesting or pointing out to them that we're going to just relocate our previously scheduled and funded meeting by a few weeks? Or whatever you think is the appropriate way to phrase that.
You bet.
Okay. Any other last items for the good of the order? So, yes, Representative Clement, Representative Dayton, you thought you were done, but I'm afraid we're going to ask you to come back one more time. We just didn't want to let you go. All right, Chairman Scott, any last items? All right, then committee, we are adjourned until a time to be determined sometime in the next 4 weeks or so.